Petition allowed. Inquiry report. Order of the disciplinary authority and the appellate authority set aside and quashed.
Right, please, your lordship. Rather, I beg your lordship's permission for listing of a matter, new matter, my lord. There is emergency. I have already, the petition has been already.
When do you want?
Day after tomorrow, 26th.
I beg to mention for listing of a contempt matter, numbers of contempt matters, US class 1462, 88, 2025.
When do you want?
My lord,
When do you want?
my lord, Friday, my lord,
Friday?
3 meters, 3 meters, 3 meters.
Okay.
Also, I have a similar pray for listing of in the admission column next week, Lords.
Okay.
Obliged.
Lordship, I beg to mention item for 24 today's daily list. The consent has been obtained from the petitioner side, Lordship.
And-
For this difficulty of the pending council, Lordship will pass about the matter for the day.
That I am for the petition.
You are for
And for the respondent number 1,
item number 24.
yes, Lordship.
It may come on my lord, 3rd of December.
Heard of?
My learned friend is requesting on 4th, let me.
Okay. Miss, your name please.
B. Chetri, Lordship.
B.
B. Chetri, Lordship. Appearing on behalf of R. Bora.
Learned counsel appearing on behalf of Mrs. R. Bora. Learned counsel for the respondent number 1 with consent from the other side. Price for listing the matter on 4th of December. Fair allowed.
So I get to mention for listing of a writ petition, lordship, matter part is suspension, lordship.
When do you want?
Day after tomorrow or next Friday?
Okay.
December. December.
Little earlier,
Next week. 28.
I have been,
May I please your lordship, I beg to mention item number 30.
Yes.
My senior is out of station,
Who is your senior?
AC Buraguhai.
Okay.
He listed the next week,
On the pair being made by Miss
Ketamuli.
J. Tamule, learned counsel for the applicant. With consent from the other side, you inform the other side.
Yeah, lordship, yes, lordship.
Is it?
I will inform.
No, you first inform.
No, already we have put a leave application, but unfortunately come to the court date case.
But since the matter is listed today, you first obtain consent from the other side, we will grant you.
Okay, lordship, I will inform to the other side.
No, you first inform. Because after you leave the court, then someone will come and again complain us. You first inform them, otherwise we will call the matter. Okay.
Lordship, I beg to mention the petition for listing lordship. It has been filed way back in the month of October lordship, but it has not been, yet been listed lordship.
Month of October.
Yes, lordship.
But did you inquire in the section why it has not been listed?
Objection was not also reflected lordship. So lordship may kindly, fix the matter, and if any objection comes,
What is the number, filing number?
13860.
What does please inquire it?
Lordship, I have another prayer, lordship. Lordship, for listing of a writ petition, lordship. It has been last listed on the month of June, lordship. So lordship may take up on Friday, lordship. May kindly. It's on admission.
Friday.
Lordship.
Okay.
may I please your lordship, I beg to mention writ petition for listing for admission hearing in any date before vacation.
When do you want the first matter?
First matter, lordship, this week, lordship.
This week. Okay.
27.
Obliged, lordship.
Motion.
Yes, motion.
28.
Obliged.
Yes.
Lordship, I beg to mention writ petition for listing for admission hearing in
When?
any date for vacation.
Before vacation.
On 9th December.
Obliged.
May I please your lordship, lordship, I beg for listing of one writ petition.
When?
Lordship on 2nd of December.
Pardon?
Lordship on 2nd December.
2nd December. Okay.
Wait, please, your lordship, I beg to mention item number 38 of the supplementary list.
38.
30, your lordship, we have filed for an additional affidavit. Not tagged along with the records. Your lordship may call for it to be tagged along with the records.
Okay.
May it please your lordship, I beg to mention for listing of a contempt case. Lordship.
Next week.
Yes.
Okay.
First, oblige, sister.
May I please your lordship, I have informed them.
Okay. Ms. So-and-so learned counsel appearing on behalf of no, with consent from the other side. Press for listing the matter after
1 week.
1 week. Pair allowed.
Oblige your.
Item number 19, Lordship. Lordship, I have some personal difficulty. I am leaving the court. May be taken after 10 days, Lordship.
Item number 19.
19, Lordship.
Okay. Mr. R. Islam, learned counsel for the petitioner. With consent from the other side, press for listing the matter after a week.
10 days.
Go ahead.
After a week.
8 December.
Oblige.
Item 4, order, Mr. Vekati, item 1.
May it please, my lord.
Yes.
My lord, my respected senior had preferred a additional affidavit, my lord, and it was given to me on the 17th, my lord. I would like to file a reply to the same.
You have filed your reply.
My lord, to the IA, I have already filed my reply. Now one additional affidavit has been filed by my respected senior. I want to file a reply to that as well.
No, today both the matters are listed.
Yes, my lord.
In respect of IA,
Yes, my lord. I seek a date to.
in IA also.
Yes, my lord. No. In the IA only it has been filed, my lord. Main case, nothing, no pleading has been exchanged.
This additional affidavit has been filed in terms of honorable court order. I have been directed to bring on record lawsuit the biometric competence statement of February 2025.
Yes.
That I have brought on record lawsuit.
Okay. You want to file a reply to the
Yes, my-
same?
Yes, my lord.
Okay. Mr. Sarma, learned counsel for the respondent opposite party submits that the applicant has filed one additional affidavit and he will file a reply to the same and press for listing the matter after
1 week, my lord.
1 week. Pair allowed. Recessal list the matter after 1 week.
My lord, interim passed earlier may continue kindly.
Interim order passed earlier in the WPC number so and so shall continue.
Deeply obliged.
Item for admission, item numbers 2 and 3, partner matter.
With this matter, we have received the
File.
my lord, we have to go through, my lord. Can this matter be fixed, my lord, tomorrow or day after, my lord? So I can, I received today morning.
Today morning you have received the file.
So yesterday was Sunday, my lord, and Sunday closed.
Lordship is observing everything.
Okay, tomorrow then, tomorrow. Heard Mr. Mahmood, learned counsel for the petitioner. No, you have completed your argument.
Yes, my lord. Yes, please.
I have completed, subject to some kind of
yes.
reply, if so.
Also heard Mr. Fukon, learned standing counsel for elementary education department. Mr. Fukon has produced the relevant file before this court. And he submits that the matter may be listed tomorrow so as to enable him to go through the file. Pair allowed, recessal list the matter tomorrow. Okay.
Item 4, partner matter.
May please your lordship, in this matter, my lord, your lordship has directly taken instructions regarding the ambiguity name of the petitioner, my lord. I have received the instruction. Same person. There was spelling mistakes in the name. Prior to, that is that prior to 2011 and later on, my lord, there is a spelling mistake, my lord. Your lordship will see the last report. The report from the PE.
He's the same person.
The same.
Okay,
Only the spelling mistake was there in the name. His correct spelling is AJHAR. Other,
okay. Now what is your pair in this petition?
My prayer is, my lord, provincialization of my service as per the recommendation of the district level scrutiny committee, my lord. That's my prayer, my lord.
And
I have been working as a headmaster, and there are provision of provincialization of headmaster also.
Hmm.
So my prayer is that as the district scrutiny committee has recommended my name, so as per as per the recommendations, my service may be provincialized. Now, that is my prayer.
no, what is the recommendation of the SLC?
SLC has been rejected earlier, my lord. Later on, when later on, my lord, SLC maybe recommended after filing of this writ petition.
SLC has recommended.
This is the second round of litigations. During the first round of litigations, my service, my recommendation was rejected by the SLC. Thereafter, this honorable court directed to pass a speaking order, my lord. And that speaking order was against me. And challenging that speaking order, I have filed this writ petition, my lord. Now,
What is the ground of why the speaking, why in the speaking order they have rejected your pair?
in the
Where is the report? Where is the
speaking
speaking
order,
order?
speaking order is at page number 120, my lord. 120.
125.
Yes, annex 18, 16 July 2022. This is the speaking order, my lord. And in that speaking order, my lord, my case was rejected on the ground that my name is not there in the DICE data up to 2011 and 12. And my case,
So, Mr. Sharma,
Lordship.
as per this report you have produced today, so he is the same person.
Lordship.
So his name is there in the DICE data.
His name is there.
my lord.
So, we will set aside this impugn order.
His name is, only thing is that the actual spelling is AJHAR.
That's all right. That's all right.
Otherwise, he's the same person.
Okay.
Person,
Then we will dispose of the petition.
with the direction to place it again before the state level committee.
No, state level committee has already recommended.
No. The state level committee has not been recommended because
Okay.
this honorable court directed pass a speaking order by the director, chairman of the state level committee. Then state level committee rejected my prayer.
Speaking order, whether SLC can pass a speaking order.
This is the passed by the director elementary education, my lord.
Based on the report of the SLC, the director has passed this order,
My lord.
Okay.
where because of the discrepancy in the name. So lordship will direct to to place it before the state level committee.
Again.
Lordship, because it has to be recommended by the state level committee. And the name of the person is said. That's data is there.
So with this observation, my lord may dispose of this matter. Only my prayer is that a time limit may be fixed, my lord. Otherwise, a time limit may be fixed for consideration of my case by the state level committee, my lord. That is fine.
Okay, within a period of 6 weeks, Mr. Sharma,
Lordship.
6 weeks,
Lordship, 2 months, lordship. It requires 2 months.
2 months.
Reasonable time.
Okay, 8 weeks.
My lord,
We'll pass order.
Lordship.
highly obliged.
Item number 5.
May I please your lordship? Lord, matter relates to, my lord, claiming the pensionary benefits, my lord. But my lord, last time some instruction was sought for.
Doctor, I may request, can it be taken after some time? I really have the instructions after some time.
Item number 6.
Doctor, here we have received an instruction. We would like to file a rapid.
Obviously file.
When you are going to file your affidavit?
They have filed already. They have filed also, reply. My lord, matter pertaining to provincialize of my service, my lord. I am entitled to provincialize under 2011 Act. Respondent authority arbitrarily provincialize my service under 2017 Act. My lord, may kindly peruse page number 36. DLC has recommended me page number 36 of the writ petition, my lord. 7 and 8, my lord.
Page number 36.
Page number 36, Annex of E, my lord. 7 and 8, Sofikul and Bazlul, my lord. Our name was listed as a 7 and 8. DLC recommended us, my lord.
Thereafter,
Thereafter, my lord, may kindly peruse page number 38. Similar situated person, they have provincialized under 2011 Act, my lord.
page number 38.
38, my lord. They are similar situated person, my lord. Assistant teacher,
Yes.
my lord, page number 39, the B form report, my lord. In 6 and 7, serial number 6 and 7, my lord. They have listed our name eligible, my lord. Remarks is eligible. Now, my lord, may kindly peruse page number 52 of their affidavit, my lord. Paragraph 5 of the last paragraph, my lord. Page number 52, my lord. They have stated that the service of the present petitioner were not provincialized under 2011 Act. At the point of time later, this service were provincialized as tutor with effect from 1/1/2020 under the Assam Educational Provincialized Service of Teacher and Young 2017 Act, my lord. Now, my lord, kindly peruse my affidavit, my lord. Affidavit reply in page number 56, my lord. After filing,
When did you file your reply?
my lord, before 2 weeks, my lord.
Before 2 weeks,
Yes.
but it is not placed on record.
Oh, my lord is,
You have not filed,
we have filed, my lord.
but it is not shown in the system.
9 again. My lord, it's required. Because 9,
Okay, better you do one thing, we will list the matter in the next week. You go to the section and inquire why it has not been listed. Did you furnish a copy to her?
well, I have already filed the student population. They have received. my lord.
Okay.
And
Her
it's
Miss
pending
M.
from
Das, Learned Counsel for
2022, my lord. It's pending from 2022. my lord.
No, that's all right. But
Ah.
without your affidavit, how
My
can
lord,
we?
my. Can you give me date, my lord?
Okay. And also heard Miss D. Musahari, Learned Extending Counsel for the Secondary Education Department. He said, thus submits that she has filed an affidavit in reply about 2 weeks back, but the same has not been placed on record. Accordingly, it is provided that registrar lists the matter on for that 1st of December. And registrar also place on record the affidavit in reply filed by the petitioner. Placed accordingly.
Deeply obliging.
7.
In this case, if the affidavit of opposition has sent for pending logic, you need 10 days time to filing.
Within 10 days.
Within 10 days.
Why 10 days? Sorted, will grant you 1 week time you file it?
On lordship last Friday, it was sent lordship.
Heard Mr.
Last was
Zedas,
given, last was already given to them.
Learned Counsel for the petitioner, and Mr. Dr. for the respondent in Secondary Education Department. Mr. Dr. Samit that he has prepared the affidavit and sent it for vetting, and he placed for listing the matter after 10 days. However, it is provided that a registrar list the matter after a week on 3rd December.
District Elementary Education Officer also need to file affidavit.
Lastly, higher education.
Please, your lordship. Can you pass over a matter for the time being, your lordship?
Who will appear?
Mr. K. Mohanta will be appearing, your lordship. Thank you, lordship.
Hello, in this case, we will require to file an affidavit. Take some time.
You are for the respondent.
Madam,
Respondent number
all respond 1 to 7.
1 to 7.
I'm appearing for the petitioner, Your Lordship. I'm appearing for the petitioner, Your Lordship.
Your name, please?
Miss C. Das.
C. Das. Heard Miss C. Das, learned counsel for the petitioner, Mr. Sayola for the respondents. Mr. Sayola submits that he may be granted some time to file one affidavit. You have not filed affidavit earlier.
Earlier we had filed, madam, the court said that some defects are there, you would have file a fresh.
File a fresh.
We'll file a fresh.
Mr. Sayola submits that this court was pleased to direct him to file a fresh affidavit. And he prays for granting him 1 week time.
Madam, at least 4 weeks, madam, after vacation. We'll file it within 2 weeks, madam. Let it come after vacation.
Yes, any objection?
Immediately after vacation.
Immediately after vacation, and press for listing the matter immediately after reopening of the vacation. Pair allowed recusal list the matter on
9. Madam, can it be on 19th or 20th?
9 January 2026.
9 there is some difficulty, madam. After 17th, anything. If the court diary permits.
No. This is of 2022 matter. Kobe, before that.
On 9 January.
Before that, madam.
7 January.
Detail of the issue.
Yes.
Item number 10.
Lordship, in this case, Lordship, one short instruction was given, but it was not adequate, Lordship. We'll send it again for detailed instruction, so we need 4 weeks time, Lordship. For filing.
My lord, for on 5th occasion, my lord, they are seeking time, my lord. We have received, my lord, the position filed by respondent number 9, my lord. To meet dispose of, my lord. Respondent 9, my lord, they have.
Pardon?
What is number 9?
Respondent number?
9. They,
We filed a in opposition.
I received
Today.
a copy, my lord. The copy.
Okay.
Which is not.
Mr. Dotto,
Lordship,
this matter was listed earlier on 7th
Yes,
of
I have just-
November.
I have just checked, Lordship, on the files, Lordship. Because earlier, said and today is for affidavit in opposition. But I have seen in the file that one instruction has been received. but
No,
it
no,
is a dispute-
instruction has already been received.
No, Lordship, it is not instruction, it is not adequate, because it is a
Mhm.
dispute between two wives, Lordship, which obviously cannot be executed in project. Anyway, Lordship, we are trying to sort it out, Lordship. So at least 4 weeks time may be granted, Lordship.
No, 4 weeks. Heard, Mr. S. Rahman, learned counsel for the petitioner. Mr. Dotto for respondent number.
I am sorry.
2, 3, and 6. Six. And you, madam, you,
9.
your name, please. Your name, P. Learned counsel appearing on behalf of Mr. Didas. Learned counsel for the respondent number 9 and Mr. Borua for respondent number? Respondent number 4. Mr. Dotto submits that he may be granted some time to file the affidavit in opposition. And though earlier some instruction have been received, the same are incomplete to file an affidavit. And accordingly, he prays for listing the matter after 4 weeks. However, Mr. Mr. Dotto is granted 2 weeks time to file the affidavit. List the matter on after 2 weeks,
On 15th December.
15th of December.
Obliged.
Item 11.
Please, your lordship.
Yes.
Lord, the notice was issued long back, my lord. Matter relates to provincialization as a mathematics, my lord, tutor, my lord, in a junior college. My lord, all the staffs had already been provincialized pursuant to an order passed by this honorable court. But my lord, I had been left out, and the reason till date is not in black and white, my lord. If I approach the authorities is also, my lord, has not said anything that why my post is kept in abeyance, my lord. So, my lord, one speaking order is there, but in that order also, my lord, there is no any reason has been cited. So, my lord, my learned friend was required to file an affidavit.
Lordship, we have received the instructions on last Saturday, your lordship. So lordship, we allow a week's time of file our affidavit. On Saturday, we had received the instruction.
Okay, let them file their
File,
affidavit. Heard Mr. A.R. Bhoya, learned counsel for the petitioner. And Ms. Musare, learned standing counsel for the respondent in secondary education department. Ms. Musare submits that she has received the instruction last Saturday. And she pays for granting her 2 weeks time to bring on record said instruction by filing an affidavit in opposition. Parallel, this is the matter on
December.
12th December.
Obliged.
Item 12.
May I please, your lordship, pass over the matter for the time?
This matter, we already are seeking time. Because in between with the DEO, we have not received the instruction, so we are waiting instruction. But already date can be given there. Effective one, well, we have not received it. We have waited, but we are waiting.
Ours Miss
And O Kumu.
and
O Kumu.
learned counsel for the petitioner and Mr. A. Fukun, learned standing counsel for the respondent in elementary education department. Mr. Fukun submits that though he was asked to obtain instruction, but he has not received the same and press for listing the matter after 1 week. After 1 week, they are allowed. They are allowed. Mr. Fukun shall bring on record the instruction to be received by filing an affidavit in opposition by next date.
Item 13. Thirteen.
None appears for the petitioner on call. However, you are appearing here. Mr. Dotto, learned standing counsel for the respondent in secondary education department, present. You have filed your affidavit, Mr. Dotto? You have filed? List the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
Item 14.
May I please? My lord, during earlier round of litigation, my lord, this honorable court has granted one SCPS benefit, my lord, at page number 33. You also will find the order. Pursuant to that order, my lord, some development took place. But my lord, the payslip provided by the AG to the block officer, my lord, and block officer has informed that that is not correct. As a result, my lord, they are not in a position to submit the bill. Introduction. Your lordship will find I have given the red mark. in the date was given 1/1/2011 in the first page. That is the fixation is done at 20,000 something, my lord. And on the third page, you also will find the date was 1/7/2010, the same amount. The benefit is given with effect from 1/1/2011, one benefit of SEPS, one increment. That is not included. As a result, there is no benefit. So the, in spite of receipt of the payslip, the block officer is not carrying the bill, my lord.
Which one, in the second page?
And not the third page, my lord, third page. In the third page, you also will find date is, I have given the red mark 1/7/2010. Basic pay is fixed at rupees 20,000 something. And same figure is reflected against the date 1/1/2011 in the first page.
No, no, Mr. Doctor, you see this page number 3, it is of dated 31st of January 2013.
Page number
Then,
3 in the third column, my lord, 1/7/2010.
No, that is of dated 31st of January 2013. And
No,
the
no,
first
my-
page is,
But in third page, third page.
yes,
Third page in the third column, you know, 1/7/2010 is given, my lord.
you see the date.
Yeah, 20,730,
Date.
1/7/10.
No. The payslip. Date of issuance of the payslip. 31st of January 2013.
Yes, Lordship.
And this first page is of dated
25,
16th of
after this
June
is
2025.
after the pronouncement of the judgment by this honorable court, my lord. But while refixing the entire, my lord, they have committed mistake because it was in the, that amount is fixed on 1/7/2010 in the year 2013. And therefore it is has to be additional increment is granted with effect from 1/1/2011. Therefore, my lord, the amount, but one increment above that amount has to be added in the with effect from 1/1/2011. But instead of doing that, my lord, they have kept the amount same in the from 1/1/2010, 1/7/2010 as well as in 1/1/2011.
Yes, Mr. Sharma.
Yes, pointed out something to me, my lord. I have to take instructions from my officials, my lord. May I pray one thing, my lord? The anomaly which is pointed out, the department, if they communicate it to the office of the AG, then it would be convenient for us.
I'm given a already it has been communicated to the AG.
And that may be reflected in the order my lord, in the instructions. If there is any.
Instruction kindly comes to, then take my. Actually, see that on the slide corner. It is a column where small is the problem, the exact.
Date of effect.
So, and-
1/1/2011.
Forwarding my lord. On the first page is given written to the accountant general for verification. And then, eight second. File number also is given. So the incumbent completed 24 years on 1/1/2001, but that's time, no provision for SPS for the parents. The rule for SPS came into force with effect from 1/1/2011. So from that date, we can start the review for the benefit. Sir, we can take instructions there. Very good.
copy of the communication I will be provided to me.
Mr. Fugon, furnish a copy to him. Heard Mr. B. Castle, learned counsel for the petitioner. Mr. A. Fugon, learned standing counsel for the respondent in Elementary Education Department. Ms. Fugon for respondent number 3 and 9. Mr. Sarma for respondent number?
7.
Respondent number 7. Respondent number 7. During the course of deliberation, Mr. Purkesto has produced the payslip issued to the petitioner dated 16/5/2025 and also to another payslip issued on 31st of January 2013. And on the basis of the said payslip, Mr. Purkesto submits that on 1st of July 2010, the basic pay of the petitioner was fixed at rupees 20,730, but while fixing the same in the payslip issued on 16th of June 2025, with effect from 1/1/2011, they have fixed the pay of the petitioner at rupees 20,730 rupees. And as such, no financial benefit has been extended to the petitioner as per the ACP.
Yes.
As per the ACP. And Mr. Fukun, learned standing counsel for the respondent in Elementary Education Department, has also produced one letter of the Deputy Secretary to the Government of Assam, addressed to the Accountant General Assam, and submits that the said anomaly has already been pointed out by the state, by the Department of School Education to the AG. But no remedial measure has been taken, initiated by the respondent Accountant General Assam. Mr. Sarma, learned counsel for the respondent AG Assam, submits that he may be provided with the document furnished by Mr. Sarma and Mr. Pukesto and Mr. Fukon, so that he may obtain necessary instruction from the respondent number 7. They are allowed. Mr. Pukesto and Mr. Fukon shall furnish the documents they have produced before the court today to Mr. Sarma, so that he may obtain necessary instruction. Justice shall list the matter on
12 December,
short date,
on 8 December.
8 December.
Item 15.
My lord, on last occasion, my lord, they were sought for time for filing affidavit, my lord. The question of my lord, attending class, my lord, by the my lord, petitioner, my lord, who is a student, my lord. He wants to, my lord, attend his classes, my lord. So, my lord, there is an order, my lord, 25, last para, my lord, regarding my lord, interim order, my lord.
So Downtown University is a private university.
Yes, my lord, but
How this,
my lord, REIT, my lord, is maintainable, my lord.
how?
It be, it be. When my lord,
I just need 1 week's time to file with our affidavit. I'm not preliminary.
You are for?
I'm for downtown university. So because of his misconduct, he was suspended from the college because he has violated the rules of the university.
but other 3 were allowed, my lord. 5 were my lord arrested, other 3, my lord, were allowed to resume their classes, 2 were not, my lord.
Well, I just need 1 week's time to file our affidavit. We will answer the issue on this maintainability.
But how this decision will help you? Because admittedly Downtown University is a private university.
Yes,
How
ma'am.
can you maintain the rate against them?
Because, my lord, it has been, my lord,
Hmm?
UGC, my lord, UGC, my lord.
Maybe.
And my lord, this judgment says like this, my lord, if my lord, private university, my lord, functions, my lord, public duty, my lord, then my lord,
No,
it is
no,
maintainable.
no. That interpretation
This,
cannot
my
be
lord,
given.
this, my lord,
So whether Downtown University is a state as defined under Article 12 of the Constitution of India.
that has been, my lord, discussed in this case, my lord. Kindly, my lord, come to last, my lord, from last to second page, my lord. Para 26, my lord, and serial number 20, my lord. From last, my lord, page 2.
So you have already been granted time to file your affidavit.
Just 1 week's time.
Okay, we will grant you that time, but you have to pay some cost. Because some urgency is there, he is a student. Third, Mr. Signer, Learned Counsel for the petitioner. Mr.
As Panikya on behalf of Mr. Ende.
S.
Panikya on behalf of Mr. Ende.
Mr.
Ende.
N. Deca, Learned Counsel for the respondent. And you for? UGC. UGC. Any other parties are there? P and 4. You? Respondent number 1. Who filed the affidavit? No one. The Learned Counsel for the respondent. Number 5. Submits that he may be granted 1 week time to file the affidavit. But it appears that the matter was last listed on 11/11/2025. And the time as spread for by the Learned Counsel for the respondent number 5 has already been granted. However, considering the submission of Learned Counsel for the respondent number 5, further 1 week time is granted. to file the affidavit, and in the event of failing to file the affidavit within a period of 1 week from today, the court will proceed to hear and dispose of the matter without the affidavit of the respondent number 5. Registrar shall list the matter on fixed date, 3rd of December.
File obligation, file obligation.
Number 35.
May I please? And the petitioners hereof, my lord, are the science teachers of the upper primary schools, my lord. What happened, my lord, the government of Assam pursuant to the mandate of the NCT to upgrade the teachers of the upper primary schools, my lord, they have introduced one program, 6 months diploma course, namely, my lord, certificate in primary education. What happened, my lord, after pursuing this, this is meant for all categories of teachers. Those who have, my lord, who are, my lord, serving as arts graduate as well as in LP schools, my lord, those teachers have been granted, my lord, the benefit of
Okay,
200.
okay. Mr. Sharma, you are appearing for the,
Not the element, but here the finance department is involved. After the official is filed, so we have also filed our strike, but there's no finance. There's some. Finance department,
who is present for finance department?
Yeah, thank you.
Okay. Oh, no.
May I please? My lord, takes your lordship to page number 43.
If I make lordship here, this will take some, lordship may fix it on a hearing day, lordship, because pleadings have been completed in this lordship. So I was, education have also filed. So,
But today the matter is fixed on the pair of both the parties.
Yes.
no, on the last date, it was the education department, lordship, they were not present, so they had sought for some time. So lordship, if I may request lordship, any hearing day, lordship, I will just request a hearing day for my landed plate on it. Yes. No, lordship, we have pleadings have been completed, I'm just making a request, lordship. Lordship may fix it for a hearing, because we have also filed an affidavit.
Heard Mr. Procastor, learned counsel for the petitioner. Mr. A. Soliha, learned standing counsel for the respondent in finance department, being respondent number 3 and respondent number 3 only.
Yes, sir.
Mr. Sharma for respondent number.
This type program, this type program. Yes.
November.
Lead come on 27th of May. 27th is a hearing day, my lord. Lead come on 27th.
27th. Respondent number 2 only. 1 and 2. And commissioner and secretary to the Government of Assam Administrative Reform Training Department. Who is appearing for?
G. Assam, my lord. It will G. Assam.
Madam, you are appearing in this matter?
G. Assam আছে তো?
Respondent number 4. NCT,
NCT I alumni.
what is your name? Adas for respondent number 5. And director SCRT, you, SCRT, SCERT.
Lordship may record Mr. Bigu, Lordship, for FCRT, Mr. Bigu appears.
But is he present in the court
Yes,
today?
He's on next Lordship.
Mr. Gogoi for SCERT, respondent number 6. None appears for the respondent number 4. Mr. Solia submits that in this matter, pleadings have already been completed and the matter may be listed for admission hearing on 27th. 27th.
Obliged.
Number 26.
May it please, yes, my lord. My lord, this matter pertains to my lord non-payment of salary to the present petitioner, my lord, who has not been paid salary since the month of April 2018. The last occasion, my lord, they had taken time on the last 3-4 occasions to file affidavit.
We have already filed our additional affidavit on 21/11/25.
21?
We have filed our affidavit. 21/11/25.
We have received this.
But it is not placed on record. Did you receive?
We have received, my lord. We have received on Friday, my lord.
Friday itself, we have filed.
I have a copy, my lord, if my lord wants to see, I have a copy.
But it is not on record. Okay, we'll call it, let it be after some time. Call it.
Item 27.
This matter was supposed to file affidavit, my lord. I have sent it for vetting. 3 days, my lord, Saturday, Sunday, Monday, being held in the state. Today also, state government is my lord on building. So I will need another 3-4 days time to get back the affidavit, my lord. Then only I-
3-4 days time. But whether in the meantime,
My lord,
electricity is restored.
yes, my lord, electricity had been restored. But my lord, the part 2 of direction of the order, that is for food, my lord, till date, the students are, my lord, without food, my lord. It has not been complied with, my lord. Direction was for, my lord, further the committee is directed to manage food and water for the student henceforth, and the cost of the same shall be managed from the fund lying in the account of the committee. My lord. A clear order, my lord, they are required to the district committee, my lord. By the,
Who is
Assam
acting
is
for
representing, my lord.
BTC?
Lord, learned senior friend D. Das Burman appeared on last occasion, my lord.
Okay, COVID, can you? Okay, after some time. Mr. Rao will grant you 3 days time
Mal.
or next Monday?
Mal.
Next Monday. But let Miss Bhoya, B. Bhoya.
We are from the kitchen.
No.
You are from BTC. Oh, why food has not been provided to the students?
Lot of the correlation may be granted lordship in the matter. We'll seek instructions. We have furnished a copy of the order to the RD lordship. But on Monday, lordship, we will.
Monday. But till Monday, how the student will survive without food and water?
Lord, I think the instruction is required from senior friend D. Das Burman, my lord, because the deputy commissioner is heading
Didas.
the, my lord.
Okay, Kobe, inform Didas. We'll take it after some time.
After some time.
And my lord, regarding this item number 8, my lord. I was in a sorry, it was called, my lord.
Obliged.
Another code, my lord.
Item number 8.
My lord. I'm very well, please, it may be taken in a hearing because it's a, it will take some time.
Item number 8.
Any hearing, my lord, because it is-
You for item number 8.
Yes, your lordship.
Lordship, I'm prepared, Lordship. I'm prepared to argue, Lordship, here matter pertains to regarding.
Father, today I'm not ready, this matter, so I am taking a date, any day, next week, in the hearing. Tuesday or Thursday night. So, this will take time. Because they are seeking something, my lord. Which needs to be asked, because finance will have to argue, my lord. They are seeking that the court should give a direction to frame rules. So these are issues, my lord.
The question of higher grade pay, Lordship. Immediately in the affidavit, reply affidavit, they have agreed to it that if a recommendation is given by the pay commission, we are ready to pay. That is my case in crux. And other request which I've made in my prayer is that a framing of service rules, which at this moment, service rules are not being framed in our cases. That is why we have prayed for a specific service rule. For that, we can get the promotion and all. One is higher grade pay and another is making of service rule. And
Okay, let it be on Tuesday, next Tuesday. Fine. Any hearing date?
on 9th,
9th of December?
yes.
9th of December. Okay. Mr. Ardhar, learned standing counsel for the respondent. Additional senior government advocate. With consent from the other side, principal listing the matter on a hearing day. Where allowed, rest shall list the matter on 9th of December.
Deeply okay.
Granting item 5.
আছে নে? মোক কোৱা নাই। পিচ দিব লাগিব বুলি গম পালো। Four 11 দিছে ন?
Yes, Mr.
My lord, it appears that benefit has been given, my lord. My lord, but I have not been received any instruction, my lord. Maybe for two reasons, my lord. The petitioner is, my lord, is hiding something, or my lord has not yet been encased in his account, my lord. My lord, can it be taken up on next Monday on that day? My lordship can close, my lord.
And it has been.
Pension payment order has been issued, my lord, and it has been disbursed, my lord, to the.
Has been drawn and dispersed.
No, Patharkandi sub treasury on so and so. Here that the leave encasement GIS GPF has also been drawn and disbursed by the undersigned, my lord. That is principal so and so. So, my lord, can it be taken up after some time, my lord, or?
Okay, after some time,
My
you
lord,
obtain
my
it. After some time.
Obliged.
Bobby.
For hearing. Item 16.
May I please, your lordship? This present petitioner, my lord, is behind the bar for 3 years, 7 months, 10 days, lordship. 3 years, 7 days, 10 months. Your lordship, while rejecting my earlier bail application,
3 years.
7 months, 10 days.
Yes.
My lord, while your lordship rejecting my earlier bail application, just one paragraph your lordship may kindly say. Page 69 is the earlier order, and page 71, para 8. At that time, lordship, 5 PWs were examined. It is not in dispute that the accused was arrested on so and so. Since then, he has been languishing jail hazard for more than 2.5 years. And after completion of investigation, has submitted charge sheet before the trial court, and trial court frames charges against him under section so and so. It is also not in dispute that out of 25 cited witnesses, 5 witnesses have already been examined, and none of them have implicated him with the offense charge. But having gone through statement of other 20 witnesses who are yet to be examined, recorded under sections 161 CRPC, it is found that some materials are there to show the complicity of the present accused, alleged offense, and unless those witnesses are examined, it would be persuasive to arrive at a conclusion that there is no material against the present petitioner. My lord, subsequently, 5 witnesses have been examined. None of the witnesses, lordship, implicated the present petitioner.
No, no. On the last date, the direction was to the additional PP to examine the statement of the witnesses who were
Of-
yet to be examined.
Yes, my lord,
Review.
There is implication against the present. He is harboring one of the melons. It used to be on the Imran Afri, only the by of offense against it, he is involved, he is harboring one of the accused involved in this thing.
Pardon?
I'd like to give one legal solution,
Ah.
regards the maintainability of the deliveries.
Why?
If Lordship permits me, I would like to place 2 judgments, Lordship.
On maintainability.
Yes. My issue is, so it kindly takes up the NIA Act of 2008 for a moment, Lordship. Lordship will find there that Lordship under NIA Act, Lordship, all the civil offences, Lordship, are exclusively tried by the NIA court. And in absence of NIA court, the power rests upon the designated sessions courts, Lordship. So, Lordship, in that view, Lordship, if any order is passed by the sessions courts, Lordship, acting as the NIA court, the same has to be under a form of the appeal.
No, no, the present case has not been registered under any of the provision of the NI Act.
It under CBAP Act. It is why, Lordship, Lordship, requesting.
No, no, is it your submission that except the NIA court, the other courts are incapable of trying the cases?
Sessions courts, Lordship.
Yes.
If Lordship kindly takes up the provision.
No, no. Is it your submission that only the courts established under the NIA Act
Yes.
are entitled to try the cases under the UAP Act?
Yes, Lordship, whether it is investigated by the central agency or by the state agencies, Lordship. If it is scheduled offences under the NIA Act, then the same has to be tried by NIA court. But in absence of a designated NIA court, the same falls under the court of session. So, Lordship, the court of session is discharging its duties as a NIA court, Lordship. And first.
No, no, no.
Yes.
That is your assumption only.
No, no,
Can you show any notification that the additional Court of Additional Sessions are designated as NIA court? Can you show any notification of the government of Assam or the union government?
we kindly take up the NIA.
No, no, no. First you show me the notification.
Lordship, this section itself is.
No, 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 no. No.
Lordship, if Section 22 of the NIA. If Lordship permits me, I will answer it.
No, no, not necessary. Not necessary.
Lordship, I am also backed by Supreme Court judgment as well as the judgment of the full bench of the Madras High Court. If Lordship just takes a glance on it.
No, no.
If Lordship is finally not convinced by.
First you show me that the court who is rejected his bail petition or the court which has been trying his case is a designated NIA court.
That is explicit from the section 22 of the.
You first show me the notification of the union government or the state government notifying that court as the designated court.
In the record itself, order dated 3/4/24 by the Constitution. Here, Lordship, what has happened? The case was first was itself sent to the Sessions Court, Lordship, in view of the Supreme Court judgment, which I have relied on, Lordship, saying that the Sessions Court is the designated court to try this offence.
No, that's all right. But you show me the notification of the union government or the state government. You simply saying that this is a NIA code, that will not serve the purpose.
Yes, sir.
You show me the notification. You inquire from your government whether they have notified the court.
Don't you kindly take up this?
No, no, no. First you show me the notification, only then I will hear you. Not otherwise. You first show me the notification. So then you come prepared. We'll take it up at 2 o'clock. Cover next sentence.
17, 88.
Made. This is a second time application, Malad.
Second time.
Second time, Malad. Petitioners are behind the bar last 1 year, 12 days, Malad.
Behind the bar for how many?
1
years?
year, 1 year, 12 days.
1 year, 12 days.
Yes, Malad.
Okay.
Acquisition is serious, Malad. 120B 30234, Malad. Acquisition, Malad. But your lordship will find the page 19, Malad, FIR. Content of the FIR is that the deceased was burned by pouring a kerosene oil by the father-in-law and mother-in-law. Thereafter, he sustained.
So the petitioners are father-in-law and mother-in-law.
Mother-in-law of the deceased victim, Malad. Father and mother of the equation number 1, Malad.
So where is the first rejection order?
Yes, Malad. Your lordship will find
Page number?
additional affidavit, Malad, page number 56, Malad.
56.
Annexure F. Malad, your lordship was pleased to reject considering the seriousness of offense and ongoing. Malad. And in last paragraph 10, Malad, your lordship requested the trial court, Malad, to complete the trial to early as possible, Malad. But
So how many witnesses were cited in the
yes,
survey?
Malad, 21 was cited.
21.
That, Malad.
21. And how many of
Out
them
of
are examined till
6,
date?
Malad. Only 6 have been examined, Malad.
Okay.
Your lordship will find I have annexed the all examined witnesses, Malad. The position, Malad. Your lordship will find page 39, Malad. Page 39, Malad. Deposition of PW1, Malad. Page 39. But he is the employee of Assam Police. He only the videographed the incident. He has not implicated the petitioner. But your lordship will find the deposition number 2. But he, the doctor, he recorded the dying declaration of the deceased. He said that when doctor said that when I recorded the dying declaration of the deceased, one police personnel and lady attendants were present. But later on, the lady attendants in his deposition said that he was not present when the doctor recorded the statement of the deceased. My submission is that, but the declaration is suspicious. That should be corroborated.
No. We will not go to examine merit of the evidence adduced by this.
Yes, Malad. Yes, Malad. My submission is that other witness testimony has not supported the dying declaration. That is one of the my argument, Malad. I have another argument also, Malad.
No. You see, the occurrence took place inside the 4 walls of the house of the accused person.
Yes, Malad.
Where the independent witness will come and depose before this court or before the trial court.
Malad.
is it your case that there were independent witnesses and those were not examined?
No, my lord, the here, my lord, the informant, my father, has not been examined, my lord. And eyewitness, my lord, Asha Kurmi, Asha worker and other villagers have been examined, my lord. They have not implicated the petitioner. They said that
No. Is it your case that those witnesses have seen the occurrence?
no,
Then,
here, my lord, they
so entire case is rest upon the dying declaration of the deceased.
deceased, my lord.
Hmm.
My only some,
Then this court is not entitled to evaluate the evidence of the doctor who has recorded the dying declaration. Right?
my only submission, my lord, my eyewitness, my lord. Here, eyewitness, my lord, has not supported the, my lord, declaration, my lord. They said that the victim was unconscious and she sustained 90% injury. So she was unconscious. This is the other witnesses statement, my lord, before the court, my lord. My lord, I am not extremely on that, my lord. I am on, my lord, I am not on the merit, strictly on merit of the case, my lord. I am praying for long incarceration of the petitioner, my lord. Petition number 1, the father-in-law, and part 2 is the mother-in-law, my lord. There is the, my lord, there is special provision for bail of women under section 437 CRPC, corresponding to section 48, my lord. In non-bailable offense, my lord. But I have collected some authority, my lord, and other courts also, my lord. In my lord, Rajasthan court, my lord, High Court, my lord, allowed the bail in triple murder case in a woman, and that was challenged before the.
Forget about the decision of the Rajasthan High Court. Have you seen the decision of the Supreme Court in the case of very recent case? Yes, Bortakor, what is the citation of that Karnataka case? Karnataka, Dorson. Dorson case.
I have not gone through, my lord.
You have not gone through it.
My lord. My lord, that was
The
challenged.
petition is available with it. You furnish a copy to him, let him go through it.
But that was challenged before the Honorable FX Court, that order, my lord, in what, my lord, the bail order was granted. And Honorable FX confirmed that, my lord, bail, my lord. In triple case murder, bail was granted only on ground of the women, my lord. Your lordship will be appreciate, my lord, kindly see, my lord, that order. I humble submission, my lord. They are behind the bar for 1 year,
No,
my lord.
Mr. Islam, you please go through the decision of this. What is the citation?
State of Karnataka also
You go through it, you come prepared at 2 o'clock. We will again hear you on this
Well,
point. 2 p.m.
Standing item 36.
May it please, yes, my lord.
Perhaps, my lord, the affidavit is here, but the other side is absent now.
No, silence. Cover. Elementary, after some time,
Well,
let the council for the elementary education department come.
Timing 37.
Lordship, in this case, Lordship, electricity connection has been.
Restored,
Yes.
yes.
So far, it Lordship, food is concerned, Lordship, they have initiated the process, Lordship. And by this week, Lordship, they have provided food, Lordship. So
By
so
this
far-
week?
Yes, Lordship.
Okay. But till then, the students have to survive.
Yes, they have, and that process is initiated, Lordship. I think that by information, I think 2-3 days they will provide the food.
Direction is.
Heard, Mr. A.R. Bhuya, learned counsel for the petitioner. Ms. D. Burman. D.D. Burman, learned additional senior government advocate for the Deputy Commissioner Baksa. And for elementary education department, Mr. Sharma, for elementary education department. Then you BTC for BTC, A. Sharma, learned standing counsel for BTC. Mr. R. Dhor, learned standing counsel for tribal affairs. Tribal affairs, Ms. K. Fokon for respondent number 1, 2, 3, and 4. During the course of deliberation, Ms. Burman submits that the electricity connection to the school has already been restored, and within 1 week, within this week, the arrangement of food and water will be managed for the students. And accordingly, she press for listing the matter after 1 week. And Mr. Ardhor, learned standing counsel for the tribal affairs, also applied for 1 week time, Mr. Ardhor. 1 week
3
time.
days I'm sitting.
To
I'm sitting 3 days. minutes.
3 days.
I will repeat next week.
3 days. 3 days time. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess at least the matter on next Monday. Monday.
On 1st December.
First session.
Timing item 5. Timing item 5.
After some time.
After some time. Okay.
Item number 18 for orders.
Lord, item 18 is a part of matter, Lordship, and the cutter is appearing, Lordship. Today, he will possibly has not come. Lordship, can I take it up tomorrow, Lordship?
Item number 18.
Yes, Lordship, 18. Both the council, they have some difficulty, Lordship. One has some issues, and they don't have come. Both the parties, Parandon Festival and they are not coming, Lordship. For the council, for the respondent, Lordship. There's that.
No, what is the status of the process? Because they have already initiated the process.
Yes, that was.
No, that information you can also collect.
I can also collect it. Then after some time.
Yes, at 2 p.m.
Yes.
Any difficulty, 2 p.m. After some time. Okay, after some time.
So one status they have given last occasion, matter when matter was not listed. Yes, this is the last statement.
Secretary has written to the director to give the some particulars to be forwarded to the finance department. Because I think it is sent to the finance department. That instruction I will take.
Okay, after some time.
Item 20.
Item number 37, Lordship, names of there are some in the quality. Lordship.
When?
Now, our name is there are not in the quality and the 37, Lordship. That-
Okay.
the-
Okay. Sorry, it is like what? Pune Local Order. They can put your idea.
May the lordship?
Yes.
In this case, on the last occasion, the
The AKB will appear in this matter, lordship.
When?
Lordship is on like lordship, the contempt matter.
Okay. Okay, after some time.
two lordship. Two lordship.
No, after some time.
Today is the state holiday.
Okay.
Saturday, Sunday, and today is located.
Okay.
It is difficult for us to get the instruction right now. Lord.
Okay.
Tomorrow, we have to tomorrow. Lord.
Okay. Okay, agreement.
Item 18.
Saturday was also holiday, lordship. So today is also holiday, lordship.
Heard Mr. A.U. Ahmed, learned counsel for the petitioner. Mr. Sisti, learned counsel appearing on behalf of Mr. N.J. Khatunier. Press for listing the matter day after tomorrow. Pair allowed recess and list the matter day after tomorrow.
26 November. And then 21.
May it please, your lordship. Before arguing this case, must your lordship go to the order dated 24/2/2025, my lord. 24/2/2025. The last before this paragraph, may I read, my lord? The court, this court is of the prima facie view that a case of contempt has been made out by the respondents. Accordingly, the director would have to answer the charges as to why he should not be punished for contempt on the next date. So and so fixed on 23/2021. Next, my lord, order 1/4/2025. Your lordship, go to the order 1/4/2025. This court, the right order dated so and so directed director to pass appropriate order keeping so and so view of the so and so. It has stated the non-ability that so could not be attributed to petitioner to benefit province. However, the order dated passed director does not appear to consonance with the order dated so and so. R. Mozumdar, learned counsel for the respondent, submits that a review order dated so and so passed WPC number so and so has been filed by the review petitioner which is yet to come up before concerned court. In view of the fact that review petition has been filed, this court is of the view that matter should be adjourned for the time being, awaiting the result of the review petition so and so. And accordingly, this matter, and thereafter, my lord, the review was dismissed, my lord. Your lordship. The review was dismissed, my lord, by order dated 28/7/2025, my lord. Now, my lord, today, my lord, is the November last part, my lord. So director may be called, my lord. Respondents may be called before the honorable court, but personally. But today they did not as per the order dated, my lord. 1/4/2025. Unit order. My lord, your lordship directed to the contemner to appear personally because there is a specific order by this honorable court to issue contempt proceeding and directed to reply, my lord, against the charges, but did not tell today they did not any file any charges. So your lordship next that fees, my lord, for by willful and deliberate violation, my lord. Personally may be present by explain his order and yeah, good.
Yes.
To take instruction by right. Regarding sometime will be conducted next case, I'll take instruction.
No, review petition was preferred by whom? By the state?
Department, I have the instruction that an appeal has been filed, regarding that, I have to take.
They always being that, my lord.
No, after dismissal or review petition, no?
Review appeal has been filed.
Where?
They have to take, I have no instruction right now.
In July, my lord,
Next week,
that was, is just my.
make up to that instruction now. On Friday.
My lord, personally may be present, my lord. This is not what is a court for honorable court proceedings. It cannot be, my lord, always, my lord. In this order has been passed, my lord. Willful and deliberate order has been passed in the year of
So
my
you
lord.
tell me where you have prepared the appeal? Division bench, what is the filing number?
I don't know what.
No, nothing.
On Friday.
Always, my lord, is cannot, my lord.
No,
At least, my
yeah,
lord, personally present before the court, my lord. The director will, my lord, explain, my lord.
At 2 PM you inform this court,
My
what
lord,
is
my
the
lord,
number?
my lord.
Number of the appeal or the filing number of the appeal, you inform this court, will grant you time.
Because.
No. Only one information is necessary, what is the filing number of the appeal?
Yes, my lord.
Next.
Item 20. Item 22.
Which visual receipt?
Madam, here, and appeal has been pending, it is 6 on 1912, WB, receipt number 270 of this 824.
WPC number? The read appeal number?
270 of 2024.
270 of 2024.
Lordship, initially this order, Lordship, in this present case, is an outcome, is a continuation of an order passed in Lordship. Number 2.
Lordship, they have filed appeal against us in
In the main-
Japan case, my lord. Another case they have filed an appeal. My lord, on the basis on which we have filed a petition in contempt pending, lordship.
But this order which is in contempt, Lordship, it is a consequence of an order passed in then another repetition. So it is followed that the order given on that repetition is followed in this case. So it is in the main repetition, we have filed an appeal and it is pending on 1912. If that is allowed, Lordship, then this order will also go, Lordship. So it's a consequential order, Lordship. The order in this present contempt petition.
When the next date is fixed?
It is
1912.
19th December.
19 December.
19th December.
Okay, after 19
Yes,
December.
sir.
Heard, Mr.
H. Rahman, lordship.
Learned counsel for the petitioner, Mr. Sisti, for the contempt. Mr. Sisti submits that one appeal has been preferred. Being WA number, Mr. Sisti number
Read appeal number 270.
27
0/2024.
2024, and the next date of the
Is 1912.
hearing is fixed on 19th of
12.
December. And a press poll listing the matter after 19th of December 2025. They are allowed recessal list the matter before vacation.
On 8 January.
No, before vacation.
Winter.
19th, okay, 19th, okay. After vacation then.
Always on 8th of January.
8 of
Oblige, lordship.
Item 23. Yeah, I think they have not taken steps properly. Something.
May I please, Sir Lordship, yes, Lordship, we have taken a fresh steps.
On which date you have taken a step?
Lordship, on 4/6/2025.
On 4th of?
Yes. 4/6/2025.
Third, miss, your name please? Your name,
H.K. Sumi.
learned counsel for the petitioner. And Mr. Sisti, you are appearing?
No, not that. I'm just informing the one. Let us have it counted.
Office note dated 14/11/2025 indicates that neither edit card nor unserved notice issued to the respondent number 2 and 3 received back by the section. Accordingly, it is provided that recessal lays the matter after a week awaiting service report upon the respondent number 2 and 3. After a week.
Bless you. Lordship.
Lordship, kindly see the last order.
Yes, Lordship, I have received an instruction from the secretary, Lordship. We have received the formal proposal from the Director of Electrification Assam on 7/11, Lordship. The state proposal will be endorsed to the finance department and higher office for concurrent. And that it will take some time, Lordship. It will be until the sent to the, we have received the proposal, it will be sent to the finance department, Lordship. So we pray for the, that is some time, Lordship.
Heard Mr. R. Islam, learned counsel for the petitioner, Mr. S.M.T. Siste, learned counsel for the complainant. During the course of hearing, Mr. Siste has produced one letter of the Deputy Secretary to the Government Assam Department of School Education, and on the basis of the aforesaid letter, Mr. Siste submits that the department has received the formal proposal of Director Elementary Education, white letter dated 7/11/2025. Then the said proposal would be endorsed to Finance Department and Higher Authority for concurrence. And as such, Mr. Siste submits that the matter may be listed after 4 weeks.
Yes.
But so as to enable the department to complete the entire process. Pair allowed, recessal is the matter after 4 weeks on.
On 7 January.
The letter produced before the court today shall be marked as Annexure B and we take to the record.
Only request is keep it part Hartman.
Okay, recessal, list the matter as part as.
Deeply obliged.
Item 26.
Non-compliance of the order dated 18/1/2024, Lordship.
Mr. Tobilder is present?
I sent someone to call him.
Okay. Okay, after some time.
27.
May please, your Lordship.
Yes.
In this case, my lord, I have challenged the order by which the SMDC of my school has been dissolved, my lord. That order is at page number 60, my lord. Hereby, my lord, SMDC of two school has been dissolved, my lord. May I read, my lord?
No, whether whether the respondents have filed their affidavit here.
They have not filed their affidavit, but my lord, in earlier, my instruction has been called for. There are two cases. Two school has, SMDC of two school has been dissolved, and one case has already been disposed of. Perhaps the instruction is available in the other case, just take, my lord. Because the instruction has been called for and notification has been produced before the honorable court, my lord. On the basis of that notifications and instruction is called for whether before dissolution of the SMDC, hearing to the representative of the SMDC done or not, my lord. And in that note, but I have the order of the other case which was disposed of. And the instruction clearly shows that no opportunity of hearing has been given, my lord. So on that line, my lord. Because so far I remember, my lord, on that day, my lord, instruction
No,
of both-
whether the service in this case has been
my
completed.
lord, on and sorry, no? Anjad Chaudhary has appeared for the private respondent, my lord. His name is shown in the cause list. Hmm? For the-
Anjad Chaudhary.
Yes, for administration, my lord. Correspondent number 5, my lord.
That's the number. Okay, Anjad Chaudhary છે. Anjad Chaudhary.
Show. But now school is functioning without SMDC, my lord. Although status quo has order to be maintained on that day, my lord, already. Nice school TSN. High school, no? Earlier it is Simon Prasa, high school.
Both are connected matter?
Yes, my lord. The same imperial order is challenged in both cases, my lord.
Yes.
Earlier it was tagged together, but later on it was separated, my lord. But why, I don't know, my lord. But one was disposed of.
So here the dissolve.
Yes, same order. Kindly have a look, my lord. Page number 60. Here we represent Tintinga High School, my lord. Other is Dolotpur High School.
Page number 16.
HSC school.
Page number 16.
Yes, my lord. 60, 60.
So this order has been interfered with.
My lord. But although interfered, but that was not affected in my school, my lord. And the order.
By the impugn order, two schools are affected.
Yes, my lord. Two separate.
In respect of one school, it has been interfered with, and in respect of you, it has not been interfered with.
My lord. Same line, my lord, this matter may be disposed of, may be available in the other file, my lord. Because on that day, so far I remembered, my lord, instruction has been delivered, my lord. And that instructions perhaps are shown, my lord. Now this without hearing us, my lord. Which cannot be as per the notification, my lord. This letter is 24/2025, my lord. That is the letter, my lord, on the basis of which that matter was disposed of, my lord. Which are issued by the Inspector of School, Lakhimpur District Circle.
Yes, madam, anything?
Lordship, we have the principal here to lordship, so for the school.
No, notice has been served. The principal failed to appear today. And you say, have you gone to the record? No.
Your lordship,
And,
to the record,
and-
lordship.
You have not gone to the
The
record.
principal, your lordship.
So for the.
No, no sort that. Oh, you go through the record, we will take it up at 2 o'clock. You see the instruction you have received and produce in the other case. Annexure X.
Highly obliged.
May I please?
Right, then.
Well, they have preferred one writ appeal ballot against this order. This order, though order was not passed by the Honorable Division Bench, my lord, Division Bench indicated that this will not be changed. It will be upheld. That indication has already been given in front of my learned friend Fatonier was there. And
No, whether that
there
appeal
is
has
no
been
stay order. There is no stay order, nothing.
Number 290/25.
Yes, there is no stay order, nothing, my lord.
Maybe let that writ appeal be disposed of first.
Yes, because the bench is not changed, that is why the case is not listed. Otherwise, it will be listed. Division bench. That is,
You go and file one application before the race day.
the order is there, that repeat, my lord, to place it before the. Be-
Except minor justice owned it solely.
Because-
So that is, I think it will be listed, no, it will be another bench compilation also. That was the last direction.
Heard Mr. Purkaiso, learned counsel for the petitioner, Mr. S.M.T. Siste, learned counsel appearing on behalf of Mr. N.J. Khatonier, learned counsel for the contender. Mr. Khatonier submits that, Mr. Siste submits that Mr. Khatonier has some inconveniences today and he is not present in the court and he applies for listening the matter. After 4 weeks,
Yes.
In the month of January, a date may be given, my lord.
after 4 weeks. Mr. Siste also submits that one writ appeal, being writ appeal number 293,
Free, public.
2025 has been filed and the same is yet to be disposed of. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recessal list the matter on
22nd January.
22nd of January.
Obliged.
President,
I think 29 lawsuits, in this case, a hearing was held on last 18th September lawsuit. After hearing, both the parties were present and lawsuit, we are awaiting that final order after the complex. So lawsuit can give some time. Here is some connection repetition also there, sir.
No, hearing was conducted on 18th of September. Why the
There's
outcome?
another connected, so this is the instruction from the director of lawsuit, mechanical.
No. Whether any appeal is pending in connection with the order being passed.
No. After hearing the both of there's some.
No.
Also there, okay.
No,
So-
we will list it tomorrow. You obtain instruction. It is of 18th of September 2025. Heard, miss?
Friday lawsuit.
No, not Friday. Tomorrow you obtain verbal instruction. Heard,
SB Saikia.
learned counsel for the petitioner, Mr. Khatonier. Learned. No, Mr. Siste for the contender.
Yes.
Mr. Siste has produced one letter dated 11th of September 2025. And on the basis of the said letter, he submits that a hearing was conducted on 18th of September 2025 at about 1 p.m. in the office chamber of the Joint Director of Secondary Education Assam, but the result is still awaited. Accordingly, it is provided that recessal is the matter tomorrow. In the meantime, Mr. Siste shall obtain necessary instruction in respect of the outcome of the hearing that was conducted on 18th of September 2025. Recessal is the matter tomorrow. The letter produced before the court today shall be marked as Annex RX and be tagged with the records. You, Mr. Siste, you have filed your Ukalatnama here.
No, it I have received, because of complaint, I had tomorrow morning also, I am filing documents.
Okay, Mr. Siste also submits that he will be filing his power by tomorrow.
31.
May I be your lordship?
Yes.
So both the petition identical, my lord, during the pendency of the suit, the petitioner expired, my lord. Lordship, for substitution their legal heirs name, my lord. The antecedent story is that, my lord, honorable court has given a direction on 18/16, my lord, to release their salary within 2 months, my lord. My lord, did not comply the order,
This
my lord, then,
application is under Section 5 of the Limitation Act.
my lord, oh, sorry, lordship, but they could not come at, in time, my lord, because, my lord, last 14 years without salary, my lord. Even expiry also, no pension to the legal heirs, my lord. This situation created by the respondent themselves, my lord, they have make them people economically crippled, my lord. I mean, impose the economic death penalty, my lord. That is situation, my lord. For this situation, my respondent is responsible, my lord. Without salary last 13, 14 years, then my lord, no pension to the legal heirs, my lord. So they could not come before your lordship in time, my lord. There is some delay, my lord. Because only reason that the tremendous financial hardship, my lord. Lordship is aware, my lord, with salary, my lord, cannot run the family nowadays, my lord. Without salary 13, 14 years. And no pension to the legal heirs, my lord. My humble prayer, if your lordship, my lord, this delay of 43 days may be condoned, my lord.
Sister, you are appearing here.
Most of the petitioners, they were accommodated as a tutor lawsuits, and they are getting their salary. That is my colleague, he is preparing an affidavit, it will be filed soon, lordship.
They are supposed to file affidavit, my lord, on August, my lord.
Affidavit is almost ready. We will file it on Wednesday. They were all accommodated as a tutor.
No, that's all right.
Yes. They are
Now,
getting salaries. It is not a fact, it's not wrong that they.
no, we are not merit of the petition now.
Yes.
We are in respect of this section 5 petition.
Oh, that
Section 5 the
that
limitation.
may be allowed, lordship. We have
That may, no objection.
In this case, no. We
Okay.
have objected.
Okay. Heard, Mr. Ahmed, learned counsel for the petitioner. No, for the applicant, and Mr. Sisley, learned counsel for the opposite party. This application under section 5 of the Limitation Act 1963 is preferred by the applicants for condonation of delay of 43 days in preferring substitution petition for pleading legal representative of late Indesor Gogoi, the petitioner number 2 in the contempt petition number 209 of 2017. Mr. Ahmed, learned counsel for the applicant, submits that the applicants have not received salaries for last 13, 14 years, and due to economic hardship, the applicant could not approach this court for substitution of legal heirs of the petitioner number 22 in the contempt petition number 209 of 2017. And the delay is not deliberate, rather it is circumstantial, and under such circumstances, he has contended to allow this application. Mr. Sisti, learned counsel for the opposite parties, submits that he has no objection in the event of allowing this application. But accordingly, taking note of the submission of learned counsel for both the parties, and also taking note of the explanations so forthcoming for the delay of 43 days in preparing the connected application, this court is inclined to allow this application. The delay of 43 days in filing the connected petition for substitution of the legal representative of late Indesor Gogoi is that's allowed.
Similar pair to next, my lord. Similar condition, similar situation, my lord. You also. He expired on 16/7/24, my lord, leaving his wife and daughter, my lord.
Or
is-
Mr.
And C4, my lord.
Learned counsel for the applicant, Mr. Sisti for the respondent, opposite party. This application under order 22, rule 3, read section 151 of the Code of Civil Procedure is preferred by the applicant for substitution of the legal representative of
Petition number
the
21.
of Indesor Gogoi, the writ petitioner number 22. Writ petitioner or petitioner in contempt case.
Petitioner in the contempt case, my lord, Indesor
Contempt
Gogoi is
case number
22, my lord.
209 of 2017. Mr. Ahmed, learned counsel for the applicant, submits that during the pendency of the contempt case number 209 of 2017, one of the applicant, namely Indesor Gogoi, suffered demise, and in his place, he is a legal representative, namely, what are the name?
Name. This is MPS.
Srimati Dipali Dotto Gogoi and Srimati Munmi Gogoi are required to be pleaded as
Dipali Dotto and Munni Gogoi Lordship.
as
Wife
party,
Dipali Dotto Lordship.
as party in place of Sri Indeswar Gogoi in contempt case number 209 of 2017. Mr. Sisley, learned counsel for the respondent opposite party submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The legal representative of the petitioner number 22 in the contempt case number so and so, namely Srimati Dipali Dotto Gogoi and Srimati Munmi Gogoi, be impleaded as party in the contempt case number 209 of 2017. In terms of this, I stands disposed of.
Next Lordship, that 3734 minus similar pair before Lordship, my Lord. He died on 16/7/24, leaving his wife and daughter only, my Lord.
I number 3734. Here the applicant is the petitioner number 21.
21, petition number 21, Lordship.
Same order. Like the first one. Here number petitioner number 21 in the contempt case. This is same order like the like the order in order number 2. In view of order being passed in the I number 3733, 3734, 3732, and 3731. Mr. Ahmed, learned counsel for the petitioner in contempt case number 209 of 2017 shall file amended cause title within 1 week from today.
My Lord.
You have to file the amended cause title.
Yes.
Lordship.
Within 1 week from today.
Wife name is Farida Begum, my Lord, and daughter is Atna Begum. In place of petition number
Okay,
21.
all right. We have taken care of the same.
Lordship, Lordship.
Recessal list the contempt case number 209 2017 on.
Lordship, some time may be given, my Lord, they are from a
Okay.
remote village, my Lord. They come, my Lord, for affidavit, my Lord. From interior place.
Sometime.
That apart, my Lord, on 12/8/25, my Lord, they issued before your Lordship, my Lord, file an affidavit, my Lord. They file, my Lord, I mean, we are allowed to time, my Lord, they have been allowed, my Lord, till that no affidavit has been filed, my Lord.
No, first you tell me when you will
In the
be
main case.
able to file this amended cause title.
Lordship,
When?
2 weeks, my Lord.
2 weeks. Over fixed date.
On 12.
Obliged.
12 December. In the meantime, Mr. Sisley shall file his affidavit.
Yes, it is ready.
Who will file?
It is filed on Wednesday.
Wednesday.
Yes, it is ready
In
by
the
my-
meantime, the learned counsel
this
for the
week.
contender shall
Copy will
file
be served
the
on us
affidavit.
before-
Definitely it will be served.
Definitely.
Yes. Obliged.
Obliged.
Affidavit. Affidavit.
Item 32.
Let me password for day, my lord, on behalf of Mr. S.C. Buragohai calling me, my lord. Due to some problem, my lord.
Mr. N. Bora, learned counsel appearing on behalf of the applicant.
S.C. Buragohai.
On
You are
behalf of
defiant.
Mr. A.C. Buragoy, learned counsel for the applicant, submits that Mr. Buragoy is absent today on account of some personal inconveniences, and accordingly he prays for listing the matter after
Next week, my lord.
Next week,
next.
next week.
March.
May please, your lordship. This repetition praying for provisions in the service of the repetitioner, your lordship. The this honorable court Vidian order dated 22/9/2025. Has the standing council of the education department has submitted a letter 22/9/2025. There is a deliberation of process of it being processed for provincial and service of the repetitioners. The education department has to place the stand.
So the matter is pending with the government.
Lordship, there is a process is being going on regarding the provincial service of the petitioners. And there is a, in this context, the is a joint committee, joint
One
sitting.
meeting was held on 24th of September 2025.
Lordships, and the honorable court has been directed to.
Yes, what information is available with you?
He granted that more time, your lordship.
The state government has
No,
placed before the honorable court regarding the outcome of that meeting, your lordships, nothing else.
so let it be on Wednesday. In the meantime, you obtain verbal instruction regarding the meeting held on 24th of September 2025. Heard Mr. H. Borua, learned counsel for the petitioner. Yes, Terang P. learned standing counsel for the respondent in secondary education department. Taking note of the order dated 22nd of September 2025, it is provided that the learned standing counsel for the secondary education department shall obtain instruction in respect of the meeting held on 24th of September 2025 and apprise this court on day after tomorrow.
Lordship.
26 November. Number 39.
Please, your lordship. Last occasion, your lordship order by order dated, my lord. 19/11/2025, my lord. Your lordship directed, my lord, granted, obtain instruction as to why he has stipend rupees 800, my lord. Your lordship order 19/11. Editor, there both. Same, my lord. That was, my lord, annex, my lord. My lord, without jurisdiction, my lord, that order has been passed, my lord. Violation of the honorable single judge as well as honorable division bench, my lord. I annex also division bench, honorable
Yeah.
division bench order, my lord.
They have written a letter to the finance department for reconsideration.
1800, my lord, this.
Yes, in respect of that stipend.
Yes, my lord. Your division bench is clearly clarified, regarding, my lord, your lordship. My
Mr.
file,
Bora, when this information will be available?
This department has concerned the file number 21/11/2025 to finance department. Reconsidered of the matter. So, 2 weeks time.
After 2 weeks. Okay.
21/11, that was passed, my lord. My lord.
Heard Mr. N. Bora, learned counsel for the petitioner. And Mr. P. K. Bora, learned counsel for the contender. Mr. Bora has produced one letter dated 21st of November 2025, written by the Undersecretary to the Government of Assam Department of School Education. And on the basis of the said letter, he submits that one file has been moved, being file E-230461 on 21st of November 2025 to the Finance within bracket SIU Department for reconsideration of the matter, and he prays for listening the matter after 2 weeks. Where allowed, recess and list the matter after 2 weeks. The letter produced before the court today shall be marked as Annexure X and be tagged with the record. List the matter on 12 of December.
Persons to the order direction by the director, I joined the school, my lord, on my lord.
No, now you are getting the scale.
No,
You are regarding the area
area,
salary.
but salary was not given, my lord, till today, where, my lord, regarding current salary, my lord.
Current salary.
That is in 1800
So
or
what-
current salary, person in their direction, I joined, but they did not, last 3 months, I have not even single penny, my lord. Penny, my
Okay,
lord.
Mr. Bora, learned, N.K. Bora, N. Bora, learned counsel for the petitioner also submits that the petitioner has not been paid the current salary also. In view of above, it is provided that Mr. P.K. Bora, learned counsel for the contender, shall obtain necessary instruction and apprise this court after 2 weeks.
My lord, that may be. taken.
I have received the instruction.
We'll call the
Lord,
matter now.
that order has been passed 5 years back, my lord.
We'll call it after some time.
Item 40.
May it please the Lord.
Yes.
My Lord, the writ petitioners here, they are really asking for some accommodation in the original writ petition. They have prayed that there be a direction to the state authorities to prepare a scheme to take them regularly, recruit them regularly in the service of TISUS, in the SSA. And for that, if necessary, by condoning their age and giving some weightage for the period of services they have already rendered, or some of them have been rendering till today. They are working as Shiksha Karmi or Shiksha volunteers. And of all these petitioners, about 14, 15 have been still continuing. Then for more than 18 years. The others have meanwhile been discontinued because they have stopped those schemes there. But nonetheless, Lordship will kindly appreciate. These are the grassroots level workers, because under the Right to Education Act, all dropouts should be caught and they should be brought to the education, I mean the school. And therefore, they have to organize them, they have to take them, visit the houses, door to door, and take those dropouts or who have not gone to the school and give them the preliminary education in those centers, and then they are joined in the mainstream. So they are in the ground they are working, but the authority has not taken care of to see their plight. Nonetheless, once there was a notification that there will be special TAT will be held for those and who can qualify, they can be accommodated.
Is that notification part of this record?
Yes, that
Page number?
is a part of this record. And then we also participated, but unfortunately all could not get through in that special TAT. Subsequently, of course, we got through the normal TAT. But even those who passed the special TAT, they are also not taken in. and we are also not taken in. This is how the whole matter is pending. Therefore, we came before this honorable court that let the authority consider and give us an opportunity to go for direct recruitment, even if necessary, treating them as a separate group, by forming a scheme, by controlling their age, and also giving them some bonus mark against the period they have already rendered, they have already served in the department. Page 45, 46, Lordship may kindly see read petition. This is our prayer. Now, meanwhile, what happened, my lord? The authority has issued a recruitment notice. They call it a special recruitment drive. They call it a special recruitment drive, and that your lordship will find at page 45 of the IA. Lordship got it, Mal.
Yes.
Page 45. This is the annexure 1 of the IA. It is dated 28 October 2025. I am placing it. Support, strengthen, and improve the quality of elementary education in the state of Assam in pursuance of government approval. File number so-and-so dated 28/10/2025. And in exercise of the powers under the Assam Elementary Education Provincialization Amendment Rules 2025. Online applications are hereby invited from willing and eligible candidates who are working as contractual and state pool pictures under Samagra Shiksha Assam SSA. We are also under that. Through the official website of DE Assam, that is so-and-so, for filling up of 10,673 upper primary, the lower primary and upper primary teachers in the initial pay band of Sasansas, plus other grade pay allowances admissible. Sasansas. Condition of recruitment, the candidates as on 10th September 2025 must be working as contractual and state pool teachers under SSA. The candidates must complete minimum 3 years of continuous service. 30th September 2025. We completed it long back. The required academic and professional qualifications for eligibility will be as per NCT norms as well as existing government and conditions. The eligible candidates shall apply online on official website from 10 a.m. of 8/11/2025 to midnight of 30/11/2025 up to 30/11. No offline application will be accepted. The Director of Elementary Education reserves the right to postpone the recruitment at any state without assigning any reason. The candidates shall apply in the same category of post that she was holding, contractual or state pool teachers, and only in one post. So they want that the post against which he was working, that should be. Against that only one can apply. Now this date was to apply from 8/11/2025. That has been slightly modified, and the next page, Lordship will find second paragraph, this notification. It was from 14/11/25 to 30/11/25. They have extended the time from 14/11 to 30/11/2025.
Oh, where is that notification by which the state has given assurance to them that their case will be considered by holding a special date?
Yes. Without a question, negotiate for Oh. Yeah. Suppose they will consider. Lordship may see, there is a decision. Move the protection, yeah, tomorrow. 30/11 লৈকে আছে। বেছি নাই নহয়। তোমালোকে এইখন ইমান ইমান লাহে লাহে কৰি থৈছা যে চবেই চকুতো নপৰে। Lordship will kindly see page 90, my lord.
I is the listed for the first time today. This is an advertisement issued by the government. So let them have some instruction, lots will pick up this matter after 2 weeks. In the meantime, if possible, they will find one if it also.
After 2 weeks, 2 weeks will be too long.
If before vacation, not significant.
No.
30th, till ultimate day is 30th.
It's 25.
Maybe.
For the first time.
Maybe.
True, the notification is also 2025. This October 2025. And well, let them take instruction. I don't have any objection to that, but this has been listed by having copy of them. Like when the copy is served, that is a good notice to the authority. And they should immediately provide the instructions.
Okay, let us list the matter in the next week. In the meantime, let them obtain instruction.
Well, at least what I am praying for. The petitioners be allowed to participate. They are going to fill up some 10,000 odd. Let them be allowed to participate in the process. Subject to the further orders from this honorable court. That will not prejudice anybody.
Whatever interim laws will pass to the next state, my lord, because I have.
They cannot dictate. This is too much.
I am not dictating.
I will have to oppose it. This is, they may say, this is my difficulty, I cannot put forward my case. But that this no interim order will be passed today. Yes, that should be, well, that should not be the practice. They may express their difficulty. That is another issue. Why not they came up with the instructions? They know that this is an urgent matter. Notice was served on them. Why not some instruction at least today? Definitely, urgent matters cannot wait. You will have to be, and it will affidavit disila amar gute case to. Elementary has not filed affidavit in this case till today. So this is how the things are being taken. This is the seriousness. 11 last date. So how can I agree to such a prayer? Because ultimately, this petition will be infructuous. Therefore, my responsible submission is, let them come up with anything they like. I do not oppose to it. But the question is to safeguard the interest of the persons. And you see, this is for those persons who once worked, those not in service. And page 90 is the judgment, Lordship will kindly see. Page 90 of the writ petition.
Okay.
This
Yes.
petition was filed by the Kamrup District Siksa Saroti Association, page 63, it starts, Annexure 2. And it went before the full court. Lordship will find the operative part, page 90. I think that will give us the idea about. Lordship got it?
Yes.
90, 44 paragraph, last paragraph, last third paragraph. Therefore, having regard to the grievance expressed by the petitioners and the discussion made above, we are of the view that it would meet the ends of justice, similar benefit as granted to the master rule workers and similarly placed employees working since last more than 10 years, not in sanction post, is extended to the six authorities. Accordingly, we direct the state to consider forming a scheme for the six authority of the above lines, which decisions have been taken with a period of 6 weeks from today. 6 weeks. Thereafter, what they did, they came up with the special tat. Next, our Lordship will find page 91. Yes, publication of notice in connection with special tat. Special tat. That special that only for to engage from time to time, can you see first para itself? This is to general instruction of all concerned that a special test for lower primary level would be conducted for contractual employees intending to appear in special test engaged from time to time under various interventions of SSA. Assam presently working under various interventions on contractual basis under SSA Assam, except the TET qualification. This and state pool teachers working under SSA having requisite qualifications as per NCT norm for appearing in the TET. This was the, and we appeared. We unfortunately could not pass out in that. Some of us have passed out. But till today, those who passed the TET, they are also not accommodated. And subsequent normal TET, we appeared and we passed. And we have the qualification. But the authority has not taken any call, forming any scheme to accommodate us, because Lordship will appreciate. Now, after this 14, 15 years, it is difficult to compete with the new entrants, those the fresh candidates. Because the marking system has also changed in the qualifying examinations. Therefore, it is difficult. That is why we had to come before this honorable court, that the scheme has not been framed. At least the government has framed such scheme in case of those daily laborers, ad hoc master workers and all. Even for accommodating teachers, they have amended the laws also, working earlier, giving weightage to their experience and bonus marks. To that extent, we have said all these are there. Therefore, and their age is running out. These people are unemployed, working in the grassroots level. Annexure 1 Lordship will find. This is the chart of the teachers petitioner.
But as per direction of the full court, they have formulated a scheme, but you have failed to pass the special TET
Yes.
examination.
That examination, what I will respectfully submit, scheme as such is not there. Because had it been the approach of the government that those who have passed that special test, they will be immediately taken in or placed in their respective commensurating post. That has not been done till today. Forget about those who could not qualify, like us. Subsequently, we have qualified. That. Therefore, there is no scheme that those who have passed either special test or normal test, but working earlier, would be accommodated like this. Now, this special drive has made by that for the first time. They say that 10,000 and odd post as a special drive. That's why I'm praying that let them go ahead, because I do not want that this should be stopped. Because all our affected persons are there. Therefore, my only prayer is that let us also participate. Those who are interested to contest, the petitioners are there. They will also contest it. If they can secure subject to the further order from this honorable court, at least their interest will be protected for the time being. I am not asking for a job. I am not asking for the stay. I only want.
Let us fix the matter on Wednesday. In the meantime, let him obtain instruction. No, last date is 38th of November. 28 will be
20. Only 2 days, 3 days will be difficult. If Lordship allows us, then we will have to undertake the exercise.
27, today it's already 28.
Bhagavad,
24.
24.
Today is 24th, man. So
24. 26.
27.
You obtain instruction only.
But 27th is better, I think. Better position, but I'll be able to, because it's quite voluminous.
Well, not voluminous. Young man, they can read it within a go. It is difficult for us only. This is not difficult at all. Let's come up 26th.
Hard Mr. KK Monto, learn it. Senior Counsel assisted by Mr. K. M. Monto, Learned Counsel for the applicant. Mr. Nayok for SSA. And Mr. A. Phukan for the respondent, state respondent. Stroke opposite parties. In this interlocutory application, 94 applicants have applied for issuing direction to the respondent authorities to accept their application online, stroke offline, stroke reserve, stroke direct, stroke not to appoint, stroke not to fill up. 94 posts against special recruitment drive notice dated 28/10/2025 authenticate Annexure 1 issued by the Director of Elementary Education Assam for filling up the post of assistant teacher in the lower and upper primary school. Mr. Phukan, Learned Counsel for the opposite state, respondent stroke opposite parties submits that he may be granted some time to obtain instruction. In this regard, where allowed recessal is the matter on 27 then
26 because Saturday will be coming next immediately thereafter. 27th will be is Thursday.
Thursday.
And after 28th, 29th again Saturday. Therefore,
Last date is 38th of November.
38th.
Yes.
All right, but as per your losses convenience, my lord.
Okay.
27th, my lord.
27th. Pardon? Why order is necessary?
They are taking
Why?
time.
No, Mr. Phukan, why order is necessary? Yes, order will be available in the website. You can obtain the certified copy.
I'm being metros. Item number 5 for admission.
May I?
Yes,
please, my
yes.
lord, I have taken the instruction, my lord. He has
received.
all the benefits, my lord.
We can close the
Yes,
matter.
yes, my lord. And regular pension is also received.
Okay. Heard, Mr. Puya, Learned Counsel for the petitioner, and Miss S. Now, Miss D. Musari, Learned Standing Counsel for the respondent in Secondary Education Department. During the course of deliberation, Miss Musari has produced one letter dated 18th of November 2025, issued by the principal, Asimia Higher Secondary School, addressing the inspector of school as this is reforming. And on the basis of the said letter, she submits that the grievance being sought to be addressed in this petition has already been addressed by the respondent authorities. Mr. Bhuya, Learned Counsel for the petitioner, also on instruction submits that the petitioner has received all the benefits which he had applied for in this petition. Accordingly, taking note of the submission of Learned Counsel for both the parties, this writ petition stands closed. The letter produced before the court today by Ms. Musari shall be marked as Annexure A and be tagged with the record.
Mal. Oblige.
Standing item 36 for admission.
May it please, my lord. On the last occasion also, my lord, I had placed the facts that the present petitioner, he has not received any salary since the month of April 2018. He's an assistant teacher. He's working in Labanpur LP school. But here, my lord, the present petitioner, my lord, he joined services on 21/2015. And after that, my lord, in the year 2016, he was transferred to Labanpur LP school, my lord. Here, my lord, may kindly take up paragraph number 4 of my petition. What happened after joining the new school, my lord?
Okay, Mr. Bhuya, whether the instructions are available with
Yes,
you?
my lord, we have filed an application also on 21/11/2025. Where in paragraph, my lord, we kindly see.
paragraph 4, my lord.
Hmm.
Transparent in response back to state the petitioner has remained unauthorized absent from duty since April 2018 without any approval, leave, or permission from the competent authority, my lord.
Hmm.
And thereafter, my lord, that's the paragraph 5, answering response back to state the several opportunities given to the petitioner to resume duties, including directions issued by the block elementary education officer, but he failed to join duty and did not regularize his long unauthorized absence.
Hmm.
Progress notice was issued, my lord, paragraph 6. Regarding his prolonged absence, the reply submitted by him was examined and found to be unreasonable, unsatisfactory, and unsupported by any valid and sufficient cause.
Hmm.
There's no justification exists to regularize his absence. My lord, the answer in your back to state that during official verification, some documents furnished by the petitioner were found to be irregular, unauthorized, and no valid proceeding or resolution supporting his claim was available in the office record. So state that the petitioner does submit any representation between 2018 to October 2024 for reduction of duty or for release of salary, making the present claim highly belated. The answer back to stated in view of the above, petitioner is not entitled to any salary for the period unauthorized absent as per service rules and on the principle of no pay and no work, no pay. That's been the stand of this final. It's a government servant, my lord. There is a process with regard to how leave has to be applied, authorized leave, my lord, and then he has to return, they have to join in service again. But nothing, my lord.
No,
2018 all along
Mr. Bhuya,
yeah.
It appears that no disciplinary proceeding was initiated
That's
against
a
it.
different issue, man. It is altogether a
No,
different issue.
but you see, this no work, no pay principle, when can be applied?
Can be
Without
This
any disciplinary
can be, my lord, the
proceeding?
service rules fixing volume with regard to this, my lord.
Hmm.
My lord, the service, this is independent with regard to this.
Hmm.
That service rule with regard to suppose, my lord, a person has been arrested. So 24 hours behind the bar, he's deemed to be suspended. Suspension is different and departmental proceeding is different.
Hmm.
So when a departmental proceeding is initiated, my lord,
No, here the petitioner was not suspended.
he was not suspended, my lord, but he was unauthorizedly absent.
Hmm.
So the principle with regard to this is available in the my lord, service rule itself. No.
No,
payment or
this
no-
Assam disciplinary service and appeal rule that is applicable.
Yes.
Yes.
Yes. In that specific.
No,
provision, if a
no,
person
no.
is not working, he's
Mr.
not entitled-
Mr. Bhuya, my specific query is
Yes.
there any provision
Yes.
for application of this principle
Yes.
without initiating any departmental proceeding, without recording any finding to that effect?
My lord, departmental proceeding is a altogether separate provisions with regard to misconducts. Now here.
No,
a
he
misconduct is
remained
a-
absent from his duty.
Yes.
Is it not a misconduct?
That may be a misconduct, my lord,
Hmm.
even then, the authorities, my lord, the rule with regard to this is a specific, that no pay, no work.
Yes, okay, show me
That is
the provision.
independent of the departmental proceeding.
Okay, okay.
Because departmental proceeding.
No,
is
you
on the-
show me the rule.
Yeah. Actually, that's something. Anisha,
Anisha, live.
yes.
Rule 17. Well, rule 7.
FR 17, my.
FR 17.
17.
Okay.
And then specific, my lord, provided an officer who is absent from duty without any authority cannot be entitled to any pay and allowance during the period of such absence.
No, that is there, but
Yes.
the question is, when, at what stage this provision can be applied
It can be applied to any person.
without any disciplinary proceeding?
Yes, that's an independent provisions with regard to this. Now, a person, my lord, this has been a condition of the service rules. That a person how to apply for leave, my lord, then it has to be sanctioned, my lord. Without sanction, it will be unsanctioned leave, my lord. So once it is applied, it has been given for suppose 1 week, my lord. He has to return and they have to report again. Then, my lord, that is been authorized leave, my lord. So unauthorized leave is any leave, my lord. A person goes for 1 week allowed, he remains absent for years. For that specific purpose, my lord. But departmental proceeding so far, my lord, is making a query with regard to this. Departmental proceeding is altogether a different, my lord. With regard to a misconduct, my lord, that regards to non-reporting or not doing his official duty, unauthorized leaves can be a part of a departmental proceeding. But here is a case wherein he has been asked repeatedly to join. He has been so cautious with regard to this. He didn't join. And the prayer made in here in the repetition, my lord, will kindly see. Repetition prayer is what? Otherwise, my lord, nobody will come to my lord. Direction likeness should not be issued, directly respond to release his area salary. So where is the question of area salary? No pay, no work is the principle, my lord.
Whether any order to that effect was passed by the authority, that
My
he
lord-
is not entitled to any pay because he remained absent for that period.
Yes, my lord. Let us see. And I can make some deliveries.
My lord, in this regard, my lord may come to
Let him complete.
My lord, will kindly come to page 56, my lord, annexure is there. And this is with regard to, my lord, the instruction that I have received, my lord. That's okay, my lord, it's now for part of the evidence, this affidavit measure.
Page number 56.
Yeah, that's been the parawise comments, my lord, made part of the record matter.
So the authority has
Can be,
not,
my lord, in the records, my lord.
pardon?
My lord, it can be, my lord, in the records. That with regard to that effect, that will be not be entitled to this, my lord, the salary, that will be on record. But on principle, with regard to the statement that has been made on, my lord, in the writ petition, it's been clear, the stand of the BTC authorities, that no pay, no.
No, that's all right. No pay, no work.
Yes.
But whether any order has been passed.
Obviously, there has to be an order, my lord, that will be reflected in the, my lord, records, my lord, records.
Better then you produce the record on next date.
My
Let me fix a short date, my lord. He's about to retire.
Whether any order was passed according
My
to
lord, may kindly come to page number 35, my lord.
page number 35.
This is in communication by the, my lord, block elementary education officer to district elementary education officer, my lord, annexure 9. Number 1 point, my lord. No explanation call, but show cause notice was served by order so and so for being unauthorized absent on 3rd of January 2009. Second, my lord, no pay stop order was served either by the BO Kokrajhar or the DIS Kokrajhar in this regard. Third, no pay stop order has been found in the office of the undersigned with regard to Sri Sakandra Bosumutari. It is specifically given, my lord, there was no pay stop order. So no order was passed, my lord.
No, that can be assumed that.
No proceeding was initiated. In fact,
Whatever-
no proceeding was initiated, my lord.
Proceeding is not required. A person has been absent in the, my lord, office for years, and for that purpose, my lord, he has been served with a show cause notice. And he has been given a reasonable opportunity of being heard. That is sufficient compliance with regard to this.
Whether he filed any reply to the so cause notice.
No, my lord, from the affidavit, it appears, my lord, no reply also, my lord.
In fact, the show cause notice is not a part of the affidavit they filed.
Whether you have filed your reply.
But as per my instruction, no show cause notice was issued upon me. It was issued upon the headmaster, my lord.
Headmaster.
Not to me, my lord.
Headmaster has not served it to you.
My lord. That is my instruction. And my lord, I have resumed service from 16th of August 2020. Their own documents at page number 41, my lord. Page number 41, my lord, may kindly come to. They have stated that, my lord, we have not resumed service in spite of giving opportunity to us, my lord. But where is the document number 41?
Hmm.
It says otherwise, my. With reference to the cited above, I have the honor to inform by later number so and so that as per report from the head teacher of Labanpur LP School and as per CRCC report of Ultapani cluster, Sri Sakradhar Bosumutari, assistant teacher Labanpur lower primary, has resumed his duties as per SMC meetings held on 26 October 2022 and 28th, has been taking classes since 16 August 2022, madam. So I've been taking classes, I've been rendering my services from 16 August 2022 to the best of my abilities, madam, without being absent, madam. I was absent from April 2018, madam. I have mentioned in paragraph number 4 and 5, madam. Because there was political pressure,
In
there was
paragraph number 4 and 5 of your
petition,
petition.
madam. Because there was political pressure, there was lot
Paragraph
of
number
threatening,
4
madam.
and 5.
4 and 5, madam, may kindly come to madam. Otherwise, there is no question why I should not render my service, madam. There has to be a strong reason, madam. At that time, I thought that area was not very conducive for me, madam. Para 4 at page, internal page 6, madam. It would be pertinent to mention herein that continuous threat having both muscle and money power. That put the person threaten the petitioner not to execute, otherwise the petitioner would have to face that. The petitioner was also assaulted in the year 2016 in this regard. The petitioner was so soft and tried not given those in FIR. Put a concern to this teacher and the incident. Verify the incidents in particular circumstances. At that point of time, the petitioner was sent off and cited to the court. And as a result, and to secure this side, the petitioner did not regularly attend classes. September 3rd. One of the petitioner was keen and eager to render his services as an assistant teacher at Labanpur LP School. But because of that incidents, threats and presumed circumstances, the petitioner was therefore no other option but to pay for the right of the situation did not put advent of COVID-19.
Okay, all right, Mr. Iqbal. Mr. Bhuya, in your affidavit, how you have dealt with this averment in the paragraph number 4 and 5? Denied.
These are grounds to asking minor without doing any job. There has to be a representation with regard to traces. There has to be some documents, my lord, with regard to this. There can be an affair with regard to this. Coming up after years, my lord, and he wants the area. How can it be like this? Taxpayers' money.
That's all right. But it appears that since 2022, he has been rendering service
And my lord, from that point of view, my lord, I have no objection.
in releasing his salary.
Done from that point of time, no issue at all. My
That,
lord, please to pass the appropriate order.
No,
But so far with regard to that, he is admitting with regard to that, my lord, that from 18 to 22, he didn't work.
no, that's all right. We'll see it.
Yeah.
But
To get the pay. That's all.
But for the period for which he has been rendering service,
Yes.
for that period you pay the salary.
Absolutely. Only that period, that should be, my lord, and can be disposed of. But so far, 18 to 22, he has not rendered service. He has not entitled to salary.
No, that's all right. We will see. You produce the file on next date. We will dispose of the matter next.
One more case was there, my lord, before taking this. It will be item number 2, Dada.
Heard Mr. Iqbal, learned counsel for the petitioner, and Mr. Bhuya, learned standing counsel for the BTC. Mr. P. N. Soma for the respondent in elementary education department. Heard in part, release the matter on when? File, you have to produce the file
Next month.
next Monday. All right. After hearing learned advocate for both the parties for quite some time, Mr. A.K. Bhuya, learned standing counsel for the respondent in BTC, is directed to produce the relevant file concerning the present petitioner on Monday.
1st December.
1st of December.
1st December, my lord, may it be 3rd December. my lord.
Okay, all right, no problem. 3rd of December.
Dibrugarh, my lord, that prefix matter. my lord. 20, item number 22, এবাৰ মই point out কৰিছিলো, I could. This matter is infractuous, my lord. Nobody has pointed out. This matter is infractuous. Why I am saying that? There was a judgment. Subsequently, my lord, policy decision was taken. Now, subsequently, they have filed another repetition, my lord, you can note that. 5861 of 2017. They were a party. And constant place is not there, my lord, because it's a voluminous judgment. 2017. Yes. So in this case, my lord, with regard to this, my lord, now a writ appeal has also been preferred. Now here, my lord, they are asking for arrear salary with regard to the first regulation and second regulation. 2017 judgment says with regard to this, my lord, that regulation after 22, wherein a government took a policy decision, SIU approval were given and situated for this post were created, my lord. They are entitled to that salary, my lord. But this is again being subjected to a writ appeal that is being filed, my lord. Sonnen Goyal, writ appeal number is not being there, my lord, now. But it has been preferred, my lord.
No,
But
is
I
it,
am on.
is it disposed of?
No, writ appeal is pending. And
Order, but for non-compliance of the order, it wasn't in 2020 directed to file 2017 to 2000. In this is post the was the
But the question is, when the final order is passed, any interim order passed earlier always merged with the final order.
absolutely, my lord.
but when this order was passed, Lordship, at that
It's okay, my lord.
by being
Mr. Bhuya, you do one thing.
Yeah.
You go to the interim order
Fine.
and also the final order. We will take up the matter.
These are old.
Yes. We'll take it up when?
My lord, on 3rd.
3rd of December. Okay. As agreed by learned advocates of both the parties, races and lays the matter on 3rd of December. In the meantime, Mr. A.K. Bhuya, learned counsel for the contender, shall obtain necessary instruction. Ms. Bora shall furnish a copy of the Devi shall furnish a copy of the petition to Mr. Bhuya so as to enable him to obtain necessary instruction. All the statements. Okay,
Depositions. All the depositions.
okay. Okay.
So my lord, in this case, petitioner was arrested on 25/10/21 or
25?
25/10/2021.
Yes.
Today is about 4 years, 1 month, Lordship, 1491 days. So in this case, from the petition, two other person, namely Pawan Kumar and Nanu Babu, they were trafficking a truck bearing registration number NL 01D3773.
Pawan Kumar and?
Pawan Kumar and Nanu Babu. They were trafficking the truck. And in the said truck,
29 packets of ganja recovered, Lordship, weighing 4 to 6.910 kg. So these persons were arrested. Then after that, Lordship, after their arrest, Lordship, statement recorded on the 67, Lordship. 67, Lordship, this person was implicated. The petitioner was implicated. And thereafter, Lordship, some more persons were also implicated, Lordship, in the final complaint. Total 5 members of accused mentioned, name of the accused persons mentioned, including the present petitioner, Lordship. Lordship will find at page number 30. In final complaint, Lordship, 1, 2, Pawan Kumar Singh and Nanu Babu Mahato. And then
Now this application is filed by 2 accused.
one accused, Achalal Sahani. Achalal Sahani.
Acha, Chelal Sahani.
Yeah, Lordship. And other 2 accused persons, number 4 and 5, one Gurbir Singh and Pappu Kumar Sahani. These 2 persons got bail from this honorable court. Because their name also, one is the Gurbir Singh, Lordship, is the owner of the truck, and Pappu Kumar Singh or Sahani also implicated by on the basis of the statement 67 statement, Lord. They got bail. It is in the additional affidavit filed by us today, Lordship. It is with the deposition or the sheet, Lordship. Page number.
Okay.
Page number 174, 168 and to 178, Lordship. So then, in this case, the accused person, one more thing is that, Lordship, in regards to the present petitioner, Lordship, his mother expired, Lordship. We have also annexed the last page, today's additional affidavit, Lordship, at page number 179, expired last week, Lordship. So in this case, Lordship, only 3 witnesses examined, and out of 3, Lordship, 2 chief and cross completed. And in regards to third, PW number 3, only chief part completed, Lordship.
Altogether 6 witnesses.
Altogether 6 witnesses, Lordship.
Cited.
No? 8 witnesses. 8 witnesses cited. Okay.
And how many of them examined so far? 6.
Only 3 examined.
3 examined.
3 examined. 3 last was 3 PW 3, and his only chief part completed. Cross part is not yet over.
3 is also not completed.
Not complete.
Okay.
This accused person implicated in some other cases also, but this
How
honorable
many total? How many cases are pending against you?
in 4 cases. Out of 4, already in 3 cases, this honorable court has granted bail, Lordship.
4 cases. 3 cases granted bail.
Lordship. Because his implication in that case also, Lordship, only on the basis of 67, Lordship. We have annexed the copies of the order sheet, Lordship.
Okay.
So, Lordship, in this case, today is about 4 years, 1 month, Lordship. Only out of 8, only 2 witnesses completed. 1 is yet to be over. Out of 8, Lordship. Within this 4 years. And in this case, each and every day, Lordship, the DLS council appeared for this accused person in the trial court. They appeared and examined the witnesses, Lordship. And one more thing is lordship, mother expired last week lordship. That is, we have an expert. The charity. Only know.
Okay.
Then
Okay. But how do you satisfy the requirement of section 37?
my lord, in this case, though, there is bar as the recovery is
The
commercial.
recovery,
Is
the
commercial.
amount of contraband substance recovered from the possession of the accused person is of commercial quantity.
Yes, of course, lordship.
So you have to satisfy the two requirement.
Two requirements, lordship, but lordship, in this case, 37, though 37 is there, because case is registered under commercial quantity. So, but lordship, in this case, from my position, nothing recovered. And lordship, on the basis of 67, already the honorable court as well as dishonorable court as well as by the apex court in time and again decided that on the basis of 67 lordship, a person cannot be convicted. So 37, though embargo is there, twin condition is there, that one son should get by the FPP to object this, and then thereafter lordship, his likelihood to not commit the offense again.
But it appears that already 4 cases are against you.
Four cases, my lord, this is the only allegation, lordship. If after my release, if again I commit such type of offense, then that will be applicable, lordship. So far my knowledge goes, lord. If after my, it is their allegation, lordship. Till and lordship, end of the trial, lordship is very much aware about the trial, lordship. So lordship, end of the trial, lordship, they cannot convict the person, lordship, because the statement they cannot establish against the person. Only the mobile contact. Mobile contact is not my name. And then thereafter, what happened, lordship, I have not communicated these two persons who carried the whole the contraband in the vehicle, lordship. I am inside the jail, lordship. The Article 21 is also there, lordship. I am inside the jail for about 4 years. They could have completed the trial, lordship. Earlier days, we completed the trials within 2 years, 1.5 years or 2 years, lordship. Nowadays, what happened is such type of NCB is the highest investigating authority in India, our country, lordship. Even after that, they could not complete this trial, lordship. The end of the trial, lordship, how can they establish a case against me, lordship? This is the statement, lordship. So many times, lordship granted bail because of that reason, lordship. We have found the judgments, lordship, or even in appeal also. So, lordship, in this case, there is the big chance of conviction of this person. Because the statement, lordship,
now
only
you
the
tell me.
statement of the accused
No,
person.
all right. Now you tell me, is there any incriminating material in the statement of the remaining witnesses who are yet to be examined?
Only the investigating officer, lordship, he can implicate the person that this statement was recorded by me and this person was implicated by this accused person.
Other co-accused.
Other, except that there is nothing so far the documents I have produced.
Okay. Okay.
That is why, lordship, in other cases, this honorable court granted bail, lordship.
Okay.
If we do have the case that from his position, the contraband was recovered, if lordship, then in that case, lordship, we cannot press like this, lordship. So this is
No,
quite different, lordship.
Okay, now you tell me one thing, whether in the condition that he will not commit any offense in future, there the person has to be convicted or his antecedent will be taken note of only.
And other courts also taking consider of that note, lordship, whether this person
Is convicted.
whether this person is that,
Convicted in other cases.
no, not convicted, this person is not convicted.
No, no. If he is convicted, only then this will be taken note of.
We have one case of coordinate bench, Lordship.
Hmm.
One person was,
No, forget about coordinate bench this
Lordship,
one.
Lordship,
You answer my query
Lordship.
that when we have to take note of the condition of 37 that he will not commit any offense in future. In that category, should we consider only the number of pending cases or only the number of cases where he has been convicted? You could not follow.
Could not follow, Lordship.
No.
My lord, Lordship is asking about the condition 37, the second condition.
Yes,
So
that he will not commit any offense.
he will not, if Lordship release a person, then this embargo will be there. If person is released on bail, if thereafter, this person was arrested, then thereafter shown arrest in three cases. Once he was arrested from railway compartment, then thereafter in other, that is also in on the basis of the 67. Then thereafter, Lordship, in these three cases, he was shown arrested. He was not released inside the jail. If after release of these four cases or in one cases, if after release he committed the offense again, then if he arrest again, in that case, Lordship, this second
Otherwise, we will not taken note of his antecedent. There's 4 number of cases pending against him. Is it your submission?
antecedent is there, but is not like that. From my position, contraband was recovered, Lordship. On the basis, anybody can implicate me also. But is there any authentic evidence that person was implicated?
No. While considering that aspect, should we take note of all those circumstances from where it was recovered? In other cases, from whose position the incriminating materials were recovered, should we take note of the same? Or should we simply take note of the cases pending against him?
It should be considered like this, Lordship, from his position, nothing was recovered. How he was implicated, that should be considered, Lordship. Because we are not, this is not new case, Lordship.
Okay. Yes, Mr. Kyle.
Page 74 of the bail application.
Application लिखा हुआ।
Correct. Yes.
Role of the petitioner agent.
Paragote and Sumon Lopez.
Is the companies of main supplier. Receiver Terminal Mato. Mato. And so. 2. Accused Acharal Sani has disclosed the name and mobile number of Patel Hospital of the mobile number statement of Patel 67. Accused Acharal Sani has disclosed in his voluntary statement Patel number 67 of NDPS said that he was consciously involved in trafficking of the ganja for money. And 4. Accused Acharal Sani has disclosed in his voluntary statement under section 67 NDPS that he has constantly in contact with the conspirator supplier, receiver, healthcare provider, Bangalore and trafficking of the ganja. Then CA mobile number so and so of Akhilal Sani has analyzed it. It was found that and analyzing this CDR is found that the accused Acharal Sani was in contact with from 25/9/2021 with respected Papu Sani. Then he made 277 calls with Papu Sani 165 times, with Amit Kumar Mathur 7 times, and with Gurveer Singh 92 times, with Kuldeep Singh from 25/9/21 to 57 times. And then paragraph six, from the analysis of CCR of mobile number so and so of accused Atilal Sani, this found that accused of Sani was in conflict with respected party for 72 parties. Accused Atilal Sani is the main conspirator that was the in of the trafficking of ganja in the state case. He was regular contact with vehicle owner and vehicle provider, which is also mentioned in his current statement. And then next page. Sani, the goal or the trafficking of the ganja. There are 6 clips here and time number so and so for 426 kg of ganja, much more than the commercial quantity. Atilal Sani is the habitual offender of NDPS Act and involved with many cases. He is also involved in NCD crime number 19 of 2020 and NCD crime of 7 of 2021 and NCD crime of 23 of 21 for the trafficking of huge quantities of NCB Guwahati, which are for much more than commercial quantity. Report from SFL FSL Caliber Health received which confirmed that there's a potential cannabis in the original samples mass number I am relying on the true judgment of one of the recent judgment of Supreme Court Lordship. Lordship is one case. Union of India versus Hitesh Kumar Hadis. And another is Union of India versus Namdev. Lordship in Union of India in this case, Lordship, paragraph 8, 9, 10, 11, 12, and 13. Lordship may come to paragraph 12. In Namdev, paragraph 12. Privacy, this court is opinion that the respondent accused is involved in drug trafficking in an organized manner. Consequently, no case for dispensing with mandatory requirement of section 37 of NTPX is made out the present case. Moreover, this court is of the view that as the accused has been charged with offense punishable within 10 years to 20 years, the rigorous imprisonment, it cannot be said that the respondent has been escalated or unreasonable long period. Even Burgess case, paragraph 13 to 22. Paragraph 13. It is contested that the High Court exercise sound discretion by harmonizing the rules of section 37 in the right of personal liberty under Article 21 of the Constitution of India. That is also placed on the position of that prolonged inclination without trial cannot be justified, particularly when delay is not attributed to the accused. The respondent submit that he has cooperated throughout the investigation and has no prior criminal incidents and holds no risk of responding or tampering with the evidence. It's argued that the new order reflects a reasonable extent of judicial discretion. After examining the case file, no inference under Article 136 of the Constitution is warranted. He also pointed out that the appellant suffers from unexplained delay in filing. Number 14. We have perused the impugn order dated so and so. Both orders proceed essentially on 4 plans. Absence of knowledge of cocaine to the respondent in the imported consignment, absence of an antecedents, length of custody, and perceived delay in conclusion of trial, and consequent conclusion that there is reasonable ground to believe that the accused is not guilty of the offense. And the stage 2 features stand up. The High Court concluded that there is no material to show that the applicant has any knowledge of cocaine in the consignment has been arraigned and without discussing the statement of the respondent and circumstances relied upon by the prosecution, including the assertion that the respondent has placed order of import, control the logistic chain, coordinate the overseas supplier, and was subject when the consignment was opened. The High Court has not examined whether these circumstances take place and taken place at the phase below was a limited purpose of paying good privacy the involvement of sufficient to attract the presumption of culpable mental state indicated under section 55 of NPPSA. Section paragraph 16. Furthermore, granting the High Court messages that there was no decision against the applicant. And declared before this court into that the real exception, the respondent in connection with earlier season of approximately 198 methamine and 9 kilograms of cocaine. That is the important from some channel and only they report the present figure. The exception is never noticed nor inserted in the incident orders. Paragraph 70, the High Court finds on the strength of these premises, according to finding that there exists reasonable ground to believe that the application is not guilty of the alleged offense, taking prolonged incarceration and likely delay as a justification for the such finding is not casual observation. It is strictly based on under section 37(1)(b)(2), which would essentially that discretionary leave and grant of leave must necessarily rest on careful appraisal of the material evidence. The conclusion of this nature is written without a trace. The prosecution's assertion of affecting and controlling this ranging upon the appreciation of evidence, which would be the domain of the trial court at the first stage. Paragraph 8. This court ordinarily shows this different reference to the decision exercised by the High Court by considering the grants of bail. However, offenses involving of narcotics, drugs, spent on a distinct territory. Section 37 enacts a specific on the grant of bail. Application of court to record satisfaction of certain requirement notice above. In addition to the ordinary is under the Code of Criminal Procedure. 19. The present case, the High Court has not undertaken any analysis of the two requirements with reference to the materials faced by the prosecution. Ordinary do not ever an allegation regarding the respondent's prior involvement in seizure of narcotic drugs and narcotic substance only days prior to the seizure of the forming of the subject matter. The present complaints, nor do they engage with the prosecution's assertion as to the respondent's role in arranging, reporting, clearing and supervising the consignment. The omission to consider these persons directly in the statutory satisfaction defined by section 37(1)(b). Then reporters to discuss about the present case. Proceeding animal submission, long information is now not a ground for releasing bail. As observed in Khalil's case in paragraph 13.
No, Mr. Kyle, you see, 4 years he is behind the bar. And within these 4 years, even you fail to examine one witness in a year.
No, but here also in this case, what is to see, he is involved in more than 4 cases. In this case, he was arrested on 25/10/21.
When the charge was framed against him?
No.
17 February 2024.
17 February 2020.
22 na? 24. In order to suspect.
If a trial goes on at this pace, then another 2 years will be required for you to complete the trial.
Please to see the orders and annexed by landed fund. Please to see how that this was taken by the prosecution as well as by the. Please. At present, there is no pleading of in the court.
Maybe they can file a petition to transfer the case. Or see if they have the intention to.
Any one of you can file the
My
petition.
lord,
You can also
my
file,
lord,
he can also file.
If they bring the witness, the DLS council always represent the accused person.
Yes, Lordship.
If they have the intention to complete the trial, there is not only the me inside the jail, some other main accused person is also the is also inside the jail lordship. So my lord, we are not only on there. How prosecution, it's a case of prosecution, my lord. It's their interest to establish against us, lordship. So if they are delaying this, then how this?
For instance, page 162, 163. Order dated 1/11/2016.
At our fault,
Yes.
our fault. If you bring, how can?
Not know if this fault, but it is the fault of the accused, from what the accused.
Some of the, this means XLL Sani or some others.
Order dated 1/11/25. Achelal Sani, then Babu
111.
Then Gaurav Kumar Singh are produced from the jail custody from DC and are demanded to till next day. The landed comes report Achelal Sani and Babu and the LADC for the pawn singer present. The special PP present in the accused persons. Accused persons, Tutu Maso and Gaurav Singh are present. Accused Papu Sani is absent because the accused.
No witnesses stand.
And madam, please, I'm getting this, I'm not hiding anything.
We have placed this.
Paying for withdrawal of his Wakalatama from the suit. No witnesses stand up. London special PP NCP has take steps. 6/15/11/25 for production and 31/26 for evidence, withdrawal of notice of from postal receipt.
My lord, in this case, no witnesses has stand up.
Then what
Though,
page
though,
164.
though the trial court was available.
Let him complete first.
Lordship.
What's the page 164? Order dated 20/10/2025.
Yes.
This record quota before the, as the PO is transferred, accused persons so are produced from jail custody. London LHCPC from Kumar is present. This one production and so on. Let's say there is no presenting of sitting of quota. See 1/11/2025 at least. And as observed by the Honorable Supreme Court in letter is judgment. That I got the paragraph to paragraph.
I took my reply divorce.
And I can listen that paragraph. Of now they are regarding the judgment of pronounced on 7th November 2025. Paragraph 13.
No, that's all right. That observation is there, but where is the diligence on your part to produce the witnesses?
What's it?
Where is the diligence in producing the witnesses before the trial court?
Here case proceeded C 2024 charge with frame. Thereafter 3 witnesses is examined. He was examined, but possibly not different on the prayer of the some of the accused persons.
No, but on these days, no witnesses have turned up.
But if the court is not there, what will see?
No, that's all right. Court is not there, but did you produce any witnesses on those days?
The order sheet reflects that nobody turned up.
Had it been the case that you have produced the witnesses and there was no presiding officer and the witnesses could not be examined on that count, is it your case?
If it is normally when the court is transferred, normally witness are
No,
not.
any court can take up the matter in that case.
The court instance page 167. Order dated 15/11/55. In written order. Here put up before me as PO is on.
You is. You. PO is on training.
From jail custody to DC and are demanded to the next date. The LADC 0.6%, 6/29/11/25 for production and 30/3/126 for
Evidence.
necessary notice of postal receipt.
Okay, we'll pass the order.
Lordship, I have two judgment have been taken.
Pardon?
Two judgment placed by me.
My lord, in this case, learned PP has submitted two judgment of the Honorable Apex Court, Lordship. In that count, Lordship, one is Union of India versus Namdeo Naka. It is 1.5 year. And then, Lordship, in this case, it was from his position, the contraband was recovered. So that is why this was rejected, and this was Vizin K. Vangsi. So in this case, Lordship, what happened? The cocaine was recovered from his position about 50.23 kilograms, and that was supplied to South Africa through the in the name of Messrs. Imito International Food India Private Limited, Lordship. And one more ground was there, parity, Lordship. That is why this was sent back to Bombay High Court to reconsider these things, Lordship. So from the position of the accused person, it was recovered. Lordship, I'd like to press the Palud Labid and other two judgment, Lordship. Yes. And petitioner was, Lordship.
Okay, we'll pass the order.
Lordship. This petitioner was not directly connected with the main accused who carried the contraband.
Item number 16.
Obliged.
kindly attend.
Submitted.
Yes, earlier on the other day, the issue was 8 witnesses have been examined so far, but none of them have implicated the present applicant. And the other issue is 25 remaining witness, whether the remaining witnesses in their statement under section 161 CRPC have implicated the present applicant or not.
Yes.
So that was the answer put by this court on the other day.
Lordship.
What is your answer?
Earlier, Lordship, the hearing officer asked me to produce the implications regarding.
Yes. Okay, you answer my question.
Regarding the examination of witnesses.
Yes.
As he is stated, Lordship, only 6 has been examined.
No. 9, 8 looking more this way.
9 has been examined.
No, regarding the statement of witnesses who are yet to be examined, whether they have implicated him or not.
My colleague has put some flag mark in the case that Lordship, who are yet to be examined. They have made some implication against the present petition. That has been flag marked in the stand of the Lordship.
My lord, I have also gone through that. May I submit on that, Lordship? My lord, 2 witnesses, where Lordship came to court on 6/6/2025, and order is there in the record. 6/6/2025, Kishmut Ali and Musa Ali. They will appear before the court for evidence, but these 2 witnesses were returned on the submission of the PP that they are not supporting the prosecution case. The order is 6/6/2025. That is on record. I flag mark that.
Two witnesses.
witnesses.
And
So-
regarding other witnesses?
So altogether, Lordship, it appears that 11, including these two witnesses, were examined. Earlier 5 on the first day of Lordship on the rejection of bail application, that was 4 to
No,
2020.
till today, 9 witnesses have been examined.
Yes. 9 plus these two witnesses returned because
11.
11.
And what about the remaining 14
Yes,
witnesses?
Lordship, I am submitting on that. On Hazrat Ali, he has not mentioned the name of the petitioner. He has implicated other co-accused. Another Samsul Haq, he stated that on the date of arrest, that is 22/4/2022, the police seized one mobile handset from Syed Ahmed. He is the petitioner. And he put his signature on the seizure list. Nothing beyond, he has not stated anything. One Abul Kalam Mondol, he was the same witnesses, he has stated the same thing as stated by Samsul Haq. He was also one of the seizure witness regarding seizing of mobile. One Shoaib Islam, he has not mentioned the name of the petitioner. He said that in his presence, 3 number of books were recovered from another co-accused, that is Hamidul.
What is the name of that witness?
Shariful Islam.
3 numbers of book recovered from the possession of the present applicant.
In his presence, 3 books were recovered from co-accused, that is Hamidul Islam, not from the petitioner. These are 61 statement. Another Lordship, Jugal Mundol, Jugal Mundol Lordship, he has stated the same thing as stated by Shariful Islam. He was also one of the seizure witnesses in respect of seizing of books from Hamidul. And one Sirajul Haq, he has not mentioned the name of the petitioner. He was the witness in seizing one vehicle from Hamidul. Vehicle was recovered from Hamidul. He put his signature. He has not mentioned the name of the petitioner. One Abu Hasaifa Alam, he stated the same thing as stated by Sirajul Haq. He was the one of the seizure witness. And Lordship, other 6 witnesses, Lordship, I have not found their statement in the case record, and also the copy furnished to the accused. I have got that copy. In the case record, I have also not found this 6 statement of the 6 other listed witnesses. I can name their name, Lordship. They were listed in the seizure list as a witness: Abbas Ali, Ainul Haq, Saddam Hussain, Zahidul Islam.
Mr. Khan, the question is, if the statement of those witnesses were not supplied to you, did you complain before the trial
Yes,
court?
yes, Lordship. That the advocate who is dealing that case, Lordship, I have discussed with him. He has not gone through that, so he will, Lordship, report the court, Lordship, regarding that. But record, Lordship, I have also verified. In my verification, I could not find those were voluminous records. All the records were sent to this honorable court, scan copy. There is also no, I have not found those. There is.
So without going through the statement of those 6 witnesses, can we adjudicate this present
In
petition?
fact, Lordship, as I inform Lordship, these witnesses are also the witnesses of some articles, those were recovered from the other co-accused. But they have not, Lordship, stated anything against the present petition. My lord, the informant, he was a police officer. In the FIR, my name was not there. 7 accused names were there in the FIR. My name was not there, but the complainant himself, Lordship, in no way, Lordship, mentioned the name of the petitioner. There is a
No, maybe it is not the requirement of law that each and every accused has to be
Yes,
mentioned in
yes,
the FIR.
absolutely, Lordship.
Yes.
So for this, the record of these Lordship witnesses, I have come across, Lordship. There is no evidence against the petitioner. He has been arrested only on that ground that Lordship, some of Lordship, he studied in Uttar Pradesh, and after completion of Lordship a Maulana degree, when he come back, Lordship, some person used to visit in his house. One of the accused, Lordship, he was also visited in his house. In the news, Lordship, that was published in the media that he has been arrested because some jihadi activities persons were visited in their house. As per some of the witnesses, Lordship, in cross-examination, they have stated. But they do not have any knowledge that he was involved in that. They are the villagers, neighbors. In their cross, they had stated these things. That when news has been published, they came to know that this person, Lordship, has been arrested because some person, Lordship, used to visit his house. No prima facie, Lordship, evidence up to this, Lordship, that the petitioner was involved in this act. There are evidences against some co-accused, Lordship. Those are named in the FIR. 7 witnesses were named. If your Lordship by this record, your Lordship will get the same thing. I am expecting, Lordship. I have gone through that. I have those documents. But I am relying to judgment. Here, 7 months, 10 days behind the bar. And 2021, 2000 I have given 21 3 SCC 713. 3 paragraphs 17, 18, and 19.
No, that is only in respect of 43D.
Paragraph, Lordship, 18 and 19. Some this 2 paragraph, Lordship, will help the case of this present petitioner. Regarding long incarceration,
Okay, in other judgment?
yeah, other judgment, Lordship, that is in Satendra Kumar until case, Lordship, just 1 paragraph. Paragraph 49.
No, is it your case that they have taken unnecessary adjournment in the trial court?
Lordship, yes, Lordship, I have annexed some this honor of the trial court. Your Lordship will find from page 74 onward, 73 onwards. Lordship, the online copy on 31/7/2025 for further evidence fixed on 14/8/2025, page 73. 14/8/25, no witness lordship present. Again, fixed for further evidence on 28/8.
No, that's all right. Whether on the earlier occasion, the prosecution side has taken step or not taken step.
Prosecutor side, lordship. Earlier, lordship, some during this period from.
No. Here, there is a clear direction in the order dated 31/7/2025 that the prosecution is to take step.
Yes.
Is it your case that despite direction of the court, they have not taken any step?
That is lordship in order itself, lordship, that is reflected.
Which one?
Lordship,
Next order, 14/8.
case 14/8, custody warrant, issue summon to the remaining witness. No, that is not reflected that no step was taken, but
Then-
they did not appear.
Maybe. But to establish your ground that your right has been violated,
Lordship,
you have to establish that that is due to the fault of the prosecution side.
my lord,
If they have taken a step upon the witnesses,
my lord, that is lordship in the paragraph 49, the Honorable Supreme Court.
pardon?
In Swatandra Kumar case that has been held, my lord, the whatever may be the reason for not examining the witnesses. Page 49. Lordship, we are, lordship, reading from middle, lordship. Page 4, paragraph 49 in Swatandra Kumar until case. Subsection 1 mandates courts to continue the proceeding on day-to-day basis till the completion of the evidence. Therefore, once trial starts, it should reach the logical end. Various directions have been issued by this court not to keep unnecessary adjournment resulting in the witness being over. However, the non-compliance of section 309 continues with day abandon. Perhaps courts alone cannot be faulted as there are multiple reasons that lead to such adjournment. Though the section makes adjournment and that too not for longer time period as an exception, they become the norms. We are touching upon this provision only to show that any delay on the part of the court or the prosecution would certainly violate Article 21.
That's all right, but there is another decision of Supreme Court in A.R. Antules case. And I'm not sure, but strength of that bench is larger than this bench.
My lord, already substantial period of lordship has already been.
Yes.
Their lordship, these witnesses are also not appearing. I don't know when this proceeding will be ended.
Yes.
Only no witness present. A reminder issue for further evidence. These are the orders. Lordship, in K.A. Nazir case, paragraph 19, I think your lordship has gone to that. This paragraph, this Honorable Supreme Court held that the another reason which persuaded us to enlarge the respondent on bail is that section 43D of the UAPA is comparatively less stringent than section 37 of the NDPS Act.
Mr. Khan,
Lordship.
here until his decision is of 4 judge bench, and this decision is of 2 judge bench.
And so far the evidence is concerned, Lordship, there is no incriminating materials against the present petitioner.
Okay, we'll see.
On merit, Lordship, on merit also, Lordship, he is entitled.
Okay, we'll see.
Lordship.
Yes, Mr. Yes, Sharma, anything to submit?
Timing item 17. 17.
Wait, please.
Yes, I have
I have gone through that.
I have referred one decision.
Yes,
That is the decision of Darshan,
yes.
Sri Darshan. So this length of detention that has to be balanced with the gravity, nature and gravity of the offense.
Yes, Milord. And there is also observation is that granting bail in.
You were behind the bar for 1 year and 13 days.
Yes, Milord.
13 days.
Yes,
So the offense is of 302
302, Milord.
and 201.
Yes, Milord.
And there is also evidence against the
Petitioners. Mother-in-law, father-in-law.
against the father-in-law.
Yes, Milord. Milord, my.
Petitioner here. Yes.
Yes, Milord, petition. Milord.
So if we balance the nature and gravity of the offense with the period you have undergone, you are undergoing incarceration in jail for 1 year and 12 days. Can it be said that your right has been violated?
Milord, the lordship will find last rejection order, Milord. I have annexed in my additional affidavit, Milord. Your lordship will find.
No, maybe, but there was no observation
No, Milord.
that in the event of failing to complete the trial,
Yes, Milord.
that this court will or the trial court will grant you bail.
Yes, but after the observation,
That was not there.
only one prosecution witness has been examined, Milord. After this order, Milord. After your lordship's rejection, Milord. And moreover, your lordship will find page number 60. Page number 60, annexure G in additional affidavit, Milord. The another daughter of the informant, that is the sister of the victim, got married with the accused number 1, Milord. Here, Milord. Another daughter of the deceased victim got married with the accused number 1, Milord, by marriage agreement, Milord. Recently, Milord. Your lordship will find.
Recently.
Yes, Milord. Page 60, Milord.
No, that cannot be a ground for granting.
My
granting
submission is
bail
that
to the-
if it was the murder, Milord, if it was the murder, Milord, that marriage of another daughter.
No. That
Milord.
cannot be a ground.
Milord,
Cannot be.
actually, it is the suicide, Milord.
No.
Milord, another my submission is that, Milord, petitioner number 2 is women, Milord. Petitioner number 2 is women, Milord. petition number 2, women, my lord, there is a provision, my lord, for special consideration of women, my lord. In under section 437 corresponding to 480 BNS assessment.
Maybe, but there are material to show that she is also involved with the offense.
My lord, there
Prima facie materials are there.
is- that, my lord, I have given, my lord, that order, my lord, Rajasthan court order, my lord, in this murder granted bail only the ground of D in triple murder case, my lord, that was confirmed by the Honorable FX Court.
Maybe.
My lord,
Okay.
your bless.
Standing item 21. For orders.
Not yet file number. Prepared but not yet file number.
But can that be a ground that sometimes in future you will file the appeal and we will not implement the order?
That is not a ground.
Then
But order was passed, my lord, 27/11/2020, more than 5 years, my lord. 5 years that was not complied with. And after issuing the contempt notice, my lord, thereafter they go to the review, my lord, and that was dismissed. So let them come before the honorable court by personally, my lord, because of that already your honorable court have already regarding
what to do? Tell me.
the
What to do? You tell me. So do we direct them to remain present or you will comply with the order?
Preparing to file, Mr. Index Attorney is preparing to file.
honorable coordinate bench already, my lord, prima facie view has been taken, my lord. By order dated, my lord, 27/11/2020.
Heard Mr. N. Bora, learned counsel for the petitioner. And also heard Mr. P.K. Bora, learned counsel for the contemnor. Mr. Bora has drawn attention of this court to the order dated 24/2/2025. Wherein it is categorically stated. No, wherein this court was pleased to observe that this court is prima facie view that a case of contempt has been made out by the respondent. And accordingly, the director should have to answer the charges as to why he should not be punished for contempt on the next date. Further, drawing attention of this court to the order dated 28/3/2025, Mr. Bora submits that the Director of Elementary Education was directed to personally appear before this court on 1/4/2025 to answer the charges as to why she should not be punished for the contempt. And drawing attention of this court to the order dated 1/4/2025, Mr. Bora submits that in view of filing of review petition, being review petition number 34 of 2025, the personal appearance of the Director, Elementary Education is dispensed with for time being. And today, Mr. Bora has produced one order of a coordinate bench of this court dated 28/7/2025 in review petition number 34/2025, and Mr. Bora submits that the said review petition has already been dismissed. In that view of the matter, the director elementary education has to be directed to remain present before this court to answer the search as per order dated 28/3/2025. Mr. P.K. Bora, learned counsel for the contempt or however submits that. Mr. N.J. Katonier, learned standing counsel for the elementary education department, has preparing one appeal, but the same is yet to be filed. Accordingly, under the given factual matrix, this court is inclined to direct the director elementary education to remain personally present before this court pursuant to order being passed on 28/3/2025 of 3rd of December. 3rd of December. To answer the search.
Director was present before this honorable court.
When?
On that day, my lord.
No, that is, they informed us that review petition was filed, that. I don't.
Now you have to answer the search as per this order,
Yes, ma'am.
28/3/2025. To answer the search as to why she should not be punished for contempt.
Marks.
List accordingly.
Marks.
Complex.
Complied with. Mr. Borua, have you gone through the, Sharma, Mr. gone through the order?
So I have gone to the order, lordship, liberty may be given to challenge the order.
What was the order of this court?
This court, lordship, the operative portion is from lordship, page 15, lordship.
Page 15.
15, lordship, para 16, lordship.
Director has to reconsider whether he is entitled or not. So we have examined. Not. Ignore that.
So, Mr. Tobilder, you see, here it is stated that the post which was advertised was transferred to another college for regularization of a person working against non-sanctioned post. When this exercise was done by the Director of Higher Education?
That's I have to get instruction about.
During the pendency of the writ petition? Or after? Or before? Writ petition number is 37.
Yes.
3711 of 2018. It was filed in the year 2018. Heard Mr. Sharma, learned counsel for the petitioner, Mr. Tobilder, learned counsel for the contender number 2. During the course of hearing, Mr. Tobilder has produced one speaking order passed by the Director, Higher Education, Assam, dated 9/5/2025. And on the basis of the said speaking order, Mr. Tobilder submits that the order of this court dated 18/1/2024 passed in WPC number 3711/2018 has been complied with. However, perusal of the said speaking order indicates that the post which was advertised indicates that the post against which the present petitioner was appointed was against the vacant post of Sri Bhuban Chandra Soikia, retired lecturer in the Department of Assamese. And the said post which was advertised was transferred to another college for regularization of person working against non-sanctioned post. In view of the above finding, and this is one of the ground for regretting the pair of the petitioner. This is one of the ground for this is the ground for regretting the proposal submitted by the principal Majuli College for appointment of lecturer in the Department of Assamese.
Actually, another ground is that he doesn't have the UGC norms. That is the main. He doesn't have the UGC norms. That is also been mentioned.
When he was appointed, this is one of the ground. One of the ground. Under the aforementioned facts and circumstances, it is provided that Mr. Tobilder shall obtain instruction as to when the post of Sri Bhuban Chandra Soikia, post held by Sri Bhuban Chandra Soikia, retired lecturer of the Department of Assamese, was transferred to another college, and to produce the relevant documents regarding transfer of the aforementioned post before this court on next date, list the matter on 2nd of December. The letter produced before speaking order produced before the court today shall be marked as annexure A and be tagged with the report.
On 9 of December.
No, why too long time?
That next week.
Otherwise, he has to again challenge the order, speaking order.
Second, I have, I think, I have got some problem. And eight is next immediate Monday also. 6th and 7th is Saturday.
Okay, 8.
Can be 27?
Okay.
Also this order you noted. Here, it has stated. That with the recent subject cited above, I have the honor to say that SMDC.
So as per that, as per that letter,
There we got it.
pardon?
There is some public educations.
No. In that letter, it has been stated that without no opportunity of being heard was given to the present petitioner, right? And on that ground, in the other case, the order has been interfered with. So his fear is that in the present case also that order has to be interfered with on the same ground.
So let me obtain my instructions.
What instruction is required?
Whether that the same order will be compliant or not.
Pardon?
With this.
No, it is already on the record. I have given it to you to go through the same. What instruction is required? Similar order.
Okay,
Similar order.
Hello.